admission item number 1.
My pleasure, Lord. My lord, in this case, the petitioner is an ex-corporator, my lord, on behalf of the villagers of High Guinea. He has filed his grievance petition under Annexure 6 before the secretary and the director of state J department, OP number 1 and 2, for the protection of only vacant land 700 decimal used as a field.
So what is that to show this has been sent to them?
My lord,
Any postal proof, nothing. What is that to show this was sent? And 17/11/2020.
my
Almost
lord,
2 years.
the defects was the translation copy
No.
were filed and now,
No, sir, this annexure 6. Come to annexure 6.
my lord,
What is there to show that you have actually sent it? Any postal proof that you sent this representation?
There is nothing, I think. There is nothing.
that is the register post and also the in the.
Where is that? Where is that? Where is the AD card? You make a fresh representation, sir.
My lord, you are-
Permitting the petitioners to make a fresh representation and after following it up on that representation.
To the
seek a-
director of estates, my lord, not the secretary, director of estates.
Whatever, that is what
both
he
secretary and the director, because
No,
the
both
only
cannot
vacant
consider.
land used for the student, out of which 2019 they have
disposed.
allotted 300
So
decimal.
you make a fresh representation.
Fresh
Yeah.
admission, my lord,
All right. Yes.
both OP number 1 and 2.
Weekly list item number 2.
Am I audible, my lord? May I audible, my lord?
Yes.
Item 2, I oblige on behalf of the villagers that in person to lordship's order, they have constructed the road, my.
Okay.
Grievance-
It's over now. Nothing survives.
Not in survey because they are
All
very happy, the villagers are very happy and
All
also congratulations given obliged to your lordships, my lord. So that
All
I am
right.
conveying it.
All right. Counsel for the petitioner states that now that the road has been constructed, the no further grievance survives, the petition is disposed of. All right.
My lord, oblige, my.
All right.
Villagers are
Very happy.
Weekly list item number 3.
In fact, due to this case, only the district administration geared up the matter and the road was.
Acha. All right.
Item number 3.
Again, representation received. All right. The petitioner's representation, annexure 5, will be examined by the Tahsildar Rera Court. And after hearing the petition and after issuing notice to the petitioners as well as opposite parties 5 and 6, and after giving them a hearing, a detailed order shall be passed, reasoned order shall be passed thereon not later than 19 September 2022 and be made available to the parties not later than 26 September. The court clarifies it is not expressed in any merits.
Weekly list item number 4.
Item number 4, may I please your lordship, my lord? My lord, here the plot number 2281, area 60 decimal, my lord, is a kism of said land is a gochoro, my lord. The
What is the
without
representation?
reservation, my lord, the BDO and BO and the project director is now constructing a Anganwadi center on the said gochoro land without the reservation. So the villagers filed a representation that is by the annexure 3 series, my lord.
All right. Petitioner's representation will be examined by the BDO.
My lord, collector Bhadrak, my lord.
All right. By the collector Bhadrak, and after giving notice to the petitioners and giving them a hearing, the reasoned order should be passed not later than 19 September, be made available to them by 26 September. The court clarifies it has not expressed any view in the matter.
developed.
Weekly list item 5. Item number 5.
Again, representation.
As here also there's a representation pending, but there is no endorsement whether it has been received by the, that is at page 22.
Hmm. Something on the left side, if you see,
That is on page 20.
page 30, if you see
Page,
on the left side, to something.
page 30 Millers doesn't have page 22.
No, annexure 5, just see that.
Annexure, yes, ma'am. Annexure 5. Annexure 5, at least a copy that is served on me, that doesn't have any endorsement.
I see. Anyway, we'll pass it over. We'll ask. Pass over.
Weekly list item number 6.
Item number
Sanitation of Petanala.
Yes, in item number 6, the instruction which I have received in the meanwhile,
Huh.
as per the decision of the Chief Secretary Orissa, the department made a detailed survey of the project
Huh.
and accordingly detailed project report has been framed for an amount of rupees 3,613.40 lakhs, which is also approved on 136 TAC held on 14/12/21. The copy of the paper is the now above proposal was placed before the government for administrative approval along with the provisions of funds. After completion of sewage, this is important, after completion of sewage treatment plant and plugging of the intent points by the WATCO, the renovation work will be taken up by this department. This is the water resources, I'm sorry, drainage division chief engineer has informed this by letter that some works have to be completed by the WATCO and this sewage treatment plant has to be.
CMC was to file an affidavit. What happened?
Yes, you know.
11/4/22 affidavit, my lord. That was not on record that day, but it should be on record now. 11/4/22.
No, we still don't have it.
Then I'll ensure that it is annexed to the records.
The affidavit of the CMC be placed on record. Say, begin with, you say none appears with the petitioner. The court has in its record copy of a letter dated 25th January 2022 from the office of the chief engineer to the additional government advocate stating that the renovation work of the Petanala at CDA Bidanasi will be taken up after completion of the sewage treatment plant and plugging of the inlet points. Ah, that's not scanned, is it?
By the WATCO. My lord, that letter is there or I will affidavit.
An affidavit dated 11th April 2022 has been filed by the CMC. Inter alia stating that on regular intervals, public awareness activities are undertaken by the health supervisors, Swachh Sathis, health staff, so as to make the public aware in general and requesting them not to dump garbage in the Petanala. Full stop. As regards renovation and maintenance of the Petanala, it is stated that it is the responsibility of the drainage division, Cuttack. And it is learned that they are taking necessary steps. This proposal being placed before the government for administrative approval, what has happened to that?
That is the current status I have to.
You say the secretary, that you say the GA department will inform the court on an affidavit by the next date whether administrative approval. This is GA department?
No, my lord, this is
Drainage division, ma'am.
drainage division, no, government of department, water resources, perhaps. That is water resources
The
department.
water resources department will inform the court on affidavit by the next date whether administrative approval for the Detailed project report submitted
Department of Water Resources, yes.
by the Office of the Chief Engineer Drainage has been granted. For provision of funds has been granted. List on 19 September.
Hopeless.
Obliged.
Six.
This is the same matter.
This
sir.
is item 6.
This is item 6, your item.
No, so we have adjourned it to 19 September, asking the government to file an affidavit on administrative approval.
Yes, but now the CDA sector, this FIDANA is the lifeline of entire sector, you know. Now, you know, may monitor this matter and is a committee so that frequently they will make cleaning, they'll make beautification. Nobody till date, never they have.
You show us some photographs, show us some videographs, something you show us, sir.
All right, I'll submit photographs. You know, see anybody, everybody of us, we are going like this way, even judges. And all that's detailed. And the mosquitoes and other insects, my lord cannot run on the line on the way. And there is garbage, there is landing of garbage.
Show us.
But he has not taken any action till date.
So show us,
And
then we can, if you give us some videos, photographs, we can then show it to Mr. Nayak. So we'll get-
I'll submit the entire photographs. And this is, you know, very unhygienic condition.
They
And
say
this
they're
is-
taking care of it. That's what they're saying in the affidavit.
What steps they have taken till date in 27.
So why did you not today, you should have produced those photographs? You knew the matters listed today. You should have come ready with photographs, videographs.
I'll submit.
Next status.
Weekly list item number 7.
This item 7, again, the representation is pending at page 10 minutes.
All right, petitioner's representation dated 24/11/2021 shall be examined by the Tahsildar,
Yes, Tahsildar would be the.
THD, and after notice to the petitioners as well as opposite party number 7, after giving an 6 and 7, and after giving them a hearing. The reasoned order shall be passed not later than 19 September and be made available to the parties not later than 26 September. The court clarifies it is not expressed any view on merits.
Weekly list item number 8.
May I please, Your Lordship? But my lord, this is a matter related to encroachment of pond. And the petitioner, while filing the writ application, had not added the encroachers as parties. So I have filed an IA number 9083 of 2022 for addition of the parties, my lord. The encroachers who have encroached upon the
All right.
pond, my lord.
The application is allowed and opposite parties 5, 6 and 7 are added to the array of respondents. Then you say in the main petition, you say the petitioner's representation dated 22/11/2021 shall be examined by the collector, Sambalpur. And after notice to the petitioners and to opposite newly added parties 5, 6 and 7, and after giving them a hearing, a reasoned order shall be passed not later than 19 September to be made available to the parties not later than 26th.
Weekly list item number 9.
Item
The
9,
court
my
clarifies it is not
lordship.
expressed.
Item 9, Your Lordship, this is a PL matter relating to an Odia cinema. This cinema was consisting of scenes regarding Lord Krishna Shakuntala of Hindu religion. But after repeated letters, the opposite parties are not providing any information till date to us. Lordship, my humble prayer that Lordship may warn the said of production house not to do such type of mistake in future and dispose of the same, Lordship. Film was already released.
My lord, when
It's
it
all
was,
infractuous now.
when it was released, when it
Nobody knows.
nobody, even at least 100 people must not have seen this picture. I don't know when this picture, this is such a
You say counsel of the petitioner states that due to subsequent developments, the petition has been rendered infractuous, it's disposed of as such. All right.
Weekly list item number 10.
Item number 10, my lord, I am in virtual note. This is a PIL matter one defect is there that wrong in nomenclature. Earlier, your lordship directed to remove the defect. In fact, all the defects are removed except this unless your lordship
All right, you say the petitioner's representation shall be examined by the collector, by your bunch, and after notice to the petitioners and opposite party 5 and 6, and after giving them a hearing, a reasoned order shall be passed.
it was supposed to be completed, the Kalyan Mandap was supposed to be completed within a certain period.
All right, not later than 19th, and make available the orders not later than 26th. Same thing. All right.
Weekly list item number 11.
I may be part of my lord, I find an amendment petition indicating the photograph of the railway station of Chhatrapur and some law of railway, that is annexure 1 and 2, that may be allowed, my lord. Thereafter, PIL.
Where is the application? Where is the application, sir?
My lord, I number 4956.
It's not in the list, sir. It is not in the list. Counsel, the petitioner states that he has filed an application for amendment. The application will be placed on record. List on 10th August.
Weekly list item number 12.
So you serve an advance copy on that.
I already served one. I already served a consultative repetition has already been served.
To state,
No,
oh, Government of India.
no.
Railways.
Railway.
Okay.
Who's for the railway? Anyone appearing for the railway?
My lord.
Sir, in this matter, are you appearing? 11, item 11.
Yes. We are appearing.
What are the instructions?
We don't have any instruction, my lord.
You better get instructions, sir. We're keeping it for 11th August. 10th August.
Obtain instruction.
You want some foot overbridge to be completed.
Yes, ma'am.
Please find out.
Yes.
All right.
Weekly list item 12.
Please, your lordships, this matter is regarding the illegal appointment of OP number 5 as Sikhya Sahayak, my lord. The real issue is here, my lord, that one person cannot pursue 2 regular courses in 1 academic year, my lord.
Well, service matters, so PIL is not entertained for service matter.
Lord, I didn't file by intending it as a PIL matter, your lordship.
Which is 1 minute. Which item is this?
Item 12, my lord.
Mohammad Zamil Ahmed. But this is indicated as a PIL only.
My lord, your lordship was of the.
Are you also applicant?
No, I am a social worker.
So we can't have a PIL for service matters, sir. That's a settled law. Counsel to the petitioner seeks leave to withdraw this petition with liberty to seek other appropriate remedies in accordance with law. Dispose of is withdrawn with liberty is grateful. All right.
Weekly list item 13.
Lord, in this case, my lord, on the last occasion, Mr. Mishra, my learned friend, had sought for time to file his reply to my intervention application, but till date it has not been filed. And neither we have been served with a copy of the reply.
And maybe pardon, my lord. Actually, on the last occasion, my lord, your lordship has given me time for a defect, removal of defect. After that, we've been filing it within due course. They will file it, my lord. Your lordship may please give me another week or 2 weeks to just file the reply objection to the intervention, my lord. In the IA number 7856, my lord.
All right. There's an intervention. You say IA number
7856
of 2022. This is an intervention application on behalf of
the project proponent, the
Vedanta Limited, the project proponent.
Yes.
The counsel to petitioner states that he will file a reply to this application before the next date. List on 5th September.
Weekly list item number 14.
In this case, both the petitioners are president of a managing committee and the secretary of a gamma committee. They have filed their grievance petition under Annexure 5 before the concerned authorities. especially in OP number 2 and 3, are eligible for cancellation of illegal alienation of a school campus land, my lord, in favor of a private organization under annexure
All right.
in paragraph.
The petitioner's representation dated 3/1/2022
number
shall be examined by the secretary. No, collector.
Secretary, GA department and the director state department, both are authority to
director is-
report the same. But he has to
Let
give
the
it,
director
they have
estates
given to
may
chief secretary
examine.
also.
Let
And
the
the
director
director
of
secondary
estates
education.
examine it.
Director of estates.
Please, not.
Director of state and the special secretary, GA department.
All right, by the Director of Estates and ex officio Additional Secretary, Government of Orissa, General Administration Department, bracket opposite party number 3, and after issuing notice to the petitioners and opposite parties 8 and 9, and after giving them a hearing, a reasoned order shall be passed not later than 19 September and be made available to the parties
Giving an
not later than
opportunity,
26
my lord.
September.
Giving an opportunity to the.
Yeah. The court clarifies it is not expressed in the matter. All right.
In the meantime, no construction shall be made because they are disturbing to make the boundary wall.
It will be open to the petitioner to seek
Inside the
appropriate
campus
interim
of-
directions from the opposite party number 3. All right.
All passable. Weekly list passed or not item number 5.
None appears as prior to pass over. Dismissed for non-passation.
Supplementary list for orders. IN number 5064 of 2022 in WPC 1761 of 2013.
As per the order, the writ section is disposed of by 18/4/2022. But assessment will complete it, but due to faceless Principal Chief Commissioner Income Tax, NFPC Delhi, who is the responsibility of assign the assessment to various officers for allotment of.
All right. For the reasons stated, the application is allowed. The time for complying with the order dated 3rd January 2022 is extended by 3 months from today.
September,
3 months from today, sir.
Yes.
Ah.
The 31st of October, sir. 31st of.
Yeah, that is not later than 31st October 2020.
Interim order to continue.
Yeah, the interim order will continue till then. For it. The earlier interim order will continue till then. The application is disposed of.
Much of.
Supplementary list item number 2. IA 17055 of 2021.
My lord, I have prayed for recalling of the order dated 4/10/2021. This order was passed without giving any notice to the opposite party number 7, who is the affected party. Number 2, the petitioner has suppressed before this honorable court regarding pendency of another writ application where interim order was passed. That disciplinary proceeding may continue, but no final order shall be passed. I have annexed that order. Number 3, but this is a PIL in service matter.
Where is this IA? 1 minute.
Well, IA number 17055 of 2021.
It's not opening up the IA. This one. It says additional affidavit. Where is the IA?
IA number 17055 of 2021. Subsequent to that, I have filed additional affidavit.
For
First
which we need to file a reply, my lord. For which we need to, because yesterday my learned senior has given me the copy at 10 PM.
Copy of the additional affidavit.
As a
IA was
bulky
given much
additional
earlier.
affidavit, my lord.
IA was given much earlier. But I'm not placing IA. I'm not placing additional affidavit. I'm just placing
That's
IA.
what we need to give the reply, my lord.
No, the additional affidavit has so many annexures, sir.
Well, an additional affidavit has so many annexures, but my point is very simple. That while passing this order, the opposite party number 7, who is the affected party,
Where is
he
it?
was not noticed. Number 2, but he has suppressed about pendency of another writ application where interim order was passed. That disciplinary proceeding may continue, but no final order shall be passed. That writ application is pending. Number 3, this is a PIL in service matter.
No. We only say that they should conclude the disciplinary proceeding against you.
No, you will also may kindly see. Well, earlier one order was passed by this honorable court by the tribunal. My lord may kindly see annexure A/7 at page 15. But that disciplinary proceeding was challenged before the tribunal and the tribunal passed an interim order. I am just placing it. So far as prayer for interim relief is concerned, the departmental proceeding may continue, but no final order is passed without leave of this tribunal. The applicant be allowed to continue in her service till finalization of the OA. Now that OA has been transferred to this honorable court and it has been renumbered as WPC OAC number 714C of 2017, and that is pending for adjudication. This fact was not brought to your lordship's notice.
No, no, you don't want the disciplinary proceeding to continue.
Well, your lordship, I want, here your lordship may kindly see, the allegation against me is that I simultaneously prosecuted +3 science course as well as vocational course. And I challenged the charge sheet before the tribunal. The tribunal passed the interim order in my favor that disciplinary proceeding may continue, but no final order shall be passed. That matter is pending before the single judge.
So we can tag this application to writ petition to that.
But my lord,
What is the prayer in the writ petition here?
Well,
It's a PIL.
it's a PIA. PIL.
PIL in a service matter anyway is not maintainable, sir.
And your lordship judgment.
We'll recall and we ask you to, you can intervene in that pending writ petition. We'll permit you to intervene in that pending writ petition. If you have any requests.
my lord,
Your lordship may just please me 1 week of time for the additional affidavit, because even they have also
Well, I am not placing additional affidavit.
But where is your?
my lord, they have filed it. And they have served as a reply, my lord. I mean, they have
No,
served
but
as
this
a
IA served when?
IA served 6 months back.
We need to reply to that. If you're not placing, my lord, my lord Singh is not placing to that.
1 minute,
we
which
need to
bench
file a
has
reply
passed this
with-
order?
your my lord, pursuant to the direction of this honorable court, that disciplinary proceeding has already been concluded and the disengagement order is passed in by the DO, that is
Oh,
annexed,
the disciplinary proceeding concluded.
my lord. Oh, that is at 49, page 49 to the additional affidavit. But that is the direction.
Concluded, it's concluded, sir, now.
My lord, action pursuant to the law, your lordship's direction, my lord, we have concluded.
No, pursuant to the direction of this honorable court in PIL, well, they have concluded the disciplinary proceeding ex parte and I have been disengaged from service.
Ex parte.
Yes.
Oh, if it's ex parte, then again the problem starts, sir. Again, he'll challenge it. This whole thing is endless cycle.
So let the other writ application be heard and this order may be recalled.
So we'll ask that order to be kept in abeyance.
My lord,
When was that order passed? That is.
Well, that order has been
2021, that is at
2021, my lord.
annexure O/7.
X by 7.
All right.
4/10/2021.
What is the locus of this Achyutan and the Nayak, the
Yes.
petitioner?
That is my point.
What is your locus, sir?
I am, my lord,
Public spirited person.
Public.
that's
same.
my- I don't know,
That's the
in
whole thing.
district of Bhadrak, in the
That's why
district of
this, no, that's why this PILs are not entertained in these kind of matters. Show us the judgment.
Yes. For a dual lordship judgment I have given and other 2 judgments.
And that order was not an expertise order, my lord. He has participated. That is reflected in the order itself.
But I have given you a lots of judgment.
57K.
Wherein several judgments of the honorable apex court has been rendered.
All right. You see, this is an application. No, this simply says additional affidavit. Where is the application?
Application is IA number 17055 of 2021. Perhaps that has come.
It is at flag B.
It's not scanned, is it? IA 17055 2021. This is an application by opposite party number 7 seeking recall of the order dated 21st January 2021 passed by this court in WP Civil PIL number 17293 of 2020. the admitted position is that the said order disposing of the writ petition was passed with this court without notice to opposite party number 7. Full stop. By the said order, direction was issued to the district education officer Badrak, bracket opposite party number 4, bracket, to conclude the disciplinary proceedings against opposite party number 7 and take a decision by reason order not later than 1st March 2021. Paragraph. As it transpires from the application, the present application by opposite party number 7, is that additional evidence? Pursuant to the order passed by this court on 21st January 2021, the disciplinary proceedings proceeded against the opposite party number 7 without her participation.
My lord, it participated, my lord. That is there in the order
He
itself.
submitted his written statement of defense.
Your lordship may see, my
He
lord.
submitted his written
40
statement of defense.
My lord,
And thereafter, my lord, in a slipshod manner, he was disengaged from service. Without
it is
following the
stated
procedure-
that where she defied the
Without
findings of
following the
judgment, her
procedure
reputation has
under
been
CCA rules.
Sorry, and these petitioner are contractual appointees, my lord.
No.
Yeah,
He-
Sikha Sahib is always,
So that
Sikha
is
Sahib is always a contractual
He
appointment, my
is
lord.
not Sikha Sahib, contract teacher. He
The
completed
contract
6 years
teacher
of
even
service.
is a contractual
He
appointment.
completed 6 years of service, therefore he is.
There is a scheme for regularization for them, but
Contractual appointment rules 2013. There is a clause in the contractual appointment rules 2013.
the
that on
status,
completion of
initial status
satisfactory
was a
service
contract
of 6
appointment.
years,
Subsequently, there
he
is a
becomes
scheme.
regular teacher.
No, but you got a copy of the inquiry report, you made a representation against that. You are aware, you participated fully, sir. Why are you saying it was ex parte?
Well, the procedure prescribed under the CCA rules were not followed.
That you challenge it, sir.
But because of the direction in the PIL manner, this order has been passed. And
I know, but the point is that you've come after all this is over.
no, my lord,
See, you could have recalled it if it had come immediately.
my lord, I could only know after the disengagement order was communicated to me.
No. Once the proceedings commenced,
But the proceeding.
you are obviously aware that the proceedings are going
The
on.
proceeding was commenced long back. I challenged the proceeding before the tribunal. The tribunal passed an interim order that disciplinary proceeding may continue, but no final order shall be passed.
Correct.
You also may kindly see that order under Annex A/7 at page 15.
So now, right, the point is this final order, you can still challenge it.
But the final order pursuant to the order passed in this PIA, that is my contention.
That's right. You can still challenge the final order, sir.
But let that order be kept in abeyance, so Lordship,
What does it matter? What's the point? See, the order was passed when 4/10/2021, my lord.
Yes.
We're in July 22, sir. How can today be kept in
Well,
abeyance?
After
It can't be kept in abeyance now.
my lord, after I come to know about that order, I immediately filed this recall petition.
What
And
to do,
this
sir?
order-
You've not, see, the.
And this
you have
order
not
was-
got this petition for hearing till now.
No, that is not listed for hearing.
Ah.
WPC OSC
So
number.
now you
715
can't
C
put in
2000.
abeyance that order, sir. It's not possible to do it now. After it's worked itself out for more than 10 months.
Well, may I suggest one thing?
Yes.
You Lordship may keep the disengagement order in abeyance.
We
and you
cannot,
Lordship may
sir.
direct-
That's the whole point.
And
Today
you
we
Lord-
cannot.
You Lordship may direct for.
It has already taken effect, sir.
Then,
Unless you said despite the disengagement, you were continued to working. Did you continue working?
well, I continued to work till disengagement.
Sir, after disengagement,
No, I
did
was
you
not.
continue to work?
No, I was not.
Then we can't, how can today we put that in abeyance?
Well, because of the direction in the
It's not
PIL,
possible,
I
sir.
have been made escape.
Sorry, sir. We can't, it's not possible to do that. You say, for recall of the order dated, you say pursuant to the order, the discipline inquiry concluded and the petition and the opposite party number 7 was disengaged by an order dated
4/10/2021.
4/10/2021, my lord.
Yes, Annex O/7 I have given.
4/10/2021. Paragraph. a perusal of the, you say, the grievance of the applicant slash opposite party number 7 is that she had filed OA 714 bracket C of 2017 before the Orissa Administrative Tribunal bracket OAT, questioning the departmental proceedings. And in that OA, an interim order had been passed on 20th March 2017 by the OAT, stating that the departmental proceedings could continue, but no final order should be passed without leave of the OAT. Full stop. It is stated that after abolition of the OAT, so what is this writ petition 13946?
My lord, in that case, my lord, when my +2 vocational certificate was cancelled, I challenged that order before this honorable court. This honorable court initially granted stay, and finally that order was finally set aside by virtue of the judgment of this honorable court passed in another case. And that was also brought to their notice. The order of the tribunal was also brought to their notice.
After the abolition of the tribunal, the said petition stands transferred to this court and has been registered as
WPC OAC number 714
of
2017.
WPC OAC
714 of 2017.
714 of 2017 and is pending in this court. Paragraph. It is stated that it is only by virtue of the order passed with this court in the present writ petition on 21st January 2021 that disciplinary proceedings have now got concluded, and which runs contrary to the interim order passed by the OAT, and those facts were not placed before this court when the order dated 21/1/2021 was passed. Paragraph. Counsel for the opposite party number 7 accordingly urges that the court should now direct that the order of disengagement passed on 4/10/2021 should be kept in abeyance. Paragraph. While it is true that notice was not issued to opposite party number 7 when the aforementioned order dated 21/1/21 was passed by this court, and further that the fact of pendency of a writ petition by opposite party number 7 before the OAT, which subsequently stood transferred to this court, was not brought to the attention of the court. The fact is that for over 8 months now, the order dated 4th October 2021 has already become operational. Full stop. In other words, the opposite party number 7 already stands disengaged for the past 8 months. Paragraph. In the circumstances, while not acceding to the prayer of the applicant, opposite party number 7, to keep the said order in abeyance, the court permits opposite party number 7 to question the said order in accordance with law and appropriate proceedings. In view of the above developments, the court is not inclined to pass any further directions in this application. It's disposed of.
Much obliged. Much obliged.
All right.
Supplementary trace admission, serial number 1, ARBP 40 of 2022.
Lordship is a 11-6 application, madam. Let me kindly see page 13 of your Lordship brief. You awarded a contract, madam, at page 13 for construction of minor bridges.
All right, so
East
fresh
Coast.
matter.
Yes, madam.
There's one Mr. Mishra who appears for the East Coast Railway, no, always?
I'm not quite sure, madam. There was the change of panel. I think the
I see. All right.
ASG, I think the ASG now is taking care of all
All
that.
right.
That's what I was told.
Notice returnable 2nd September.
Diploma.
All right.
Supplementary trace admission item number 2.
Item number 1, we are appearing, my lord. Item number 1.
Then you say Mr. Pari accepts notice. Reply be filed within 4 weeks, rejoined for the next date. 2nd September. All right.
Item number 2.
I may plead your lordship.
Yes, please.
Virtual.
Yes.
Is a criminal division matter dismissed for default for non-prosecution.
All right.
And
We'll allow this. You tell us what the main matter is about. For the
Main
reason
matter is
stated, the application is allowed, the order is recalled, and criminal revision 759 of 2003 is restored to file. Yes.
let me fix a date authorized by the, here is a case where during the pendency of the revision, there is a compromise between the parties.
I see.
And all the parties have filed their compromise petition before lordship.
I see.
Now lordship must be examined.
Where is the original file?
Now your
Sorry.
lordship must be examined in law whether it lordship can compound it and can close the proceedings or not. I will
Ah,
cite some judgment, my lord. I will cite some judgment.
no, but the other side is here.
Yes,
No, are the other side, I mean, is the other side here?
yes, my lord. Other side have also filed a compromise petition and they have perhaps they have appeared. Some of the lawyers have appeared perhaps for them.
No, no, no. Today they are not there, correct?
Let me fix a date, my lord, then it will be better.
All right. In the main revision petition, 759 you see today this application has been restored to file. The recall of the order.
It is purely question of law.
22nd April 2022. Mr. Katkia is there. What about the private opposite parties?
Because I only am having the restoration application. The main application is not with me.
Sir, in the revision petition, who are there? Only state is the party. Mr. Mishra?
Yes, state is only the party.
Aha.
But the victims, those who are injured by lot, because all are brothers. All are brothers within the family. The case is about 20 years back. Meanwhile, though there is a conviction to the petitioners, both in court below as well as in appellate court.
Conviction has been upheld by the appellate court.
Appellate court, while pending revision, there was a
And it is
compromise.
a revision.
The compromise petition along with that interim application, perhaps that is there.
In fact, my lord, with kind permission, my lord, one Soumyakanta Tripathi has already entered appearance on behalf of the government and the injured persons, my lord.
Who has entered appearance?
Only the probably it is listed. One Soumyakanta Tripathi.
Soumya Ranjan Tripathi.
Yes, but because probably it is he has appeared in the criminal revision. Once revision will be listed, no, his name. Yes, madam. His name will come automatically.
What was the application number in the criminal division for entering the compromise? Are you aware of that application number? Because that's not showing up here. And Soumya Ranjan Tripathi's wakalat is there.
No, yes, my lord.
His wakalat is also not there.
My lord.
Mr. Soumya Ranjan Tripathi's wakalat nama is not there.
That must that was filed as per his.
No, you have the criminal division case. Entire case is there.
That might not have been tagged to the record because it is a disposed of case, my lord.
No, but
It must
still,
be
the original record is here.
Yes, original record has been disposed of, my lord.
No, sir, it is here.
No, that is there, my lord. But the office, since it has been disposed of, my lord, the wakalatnama might have gone to the office, my lord. The office might not have tagged to the record. Because after getting it, your lordship may call it the next day.
The board is informed that one Mr. Soumya Ranjan Tripathi, advocate, has filed a wakalatnama on behalf of the injured victims, with whom, according to Mr. Kali Prasanna Mishra, senior advocate for the petitioner, there is already a compromise entered into by the petitioner. Full stop. notice without process fee be issued to Mr. Soumyaranjan Tripathi to remain present on the next date. It may be noted that his Vakalatnama is not on the record. List on 12th August. 12th August.
My lord, meanwhile, I'm told that the warrant has been issued.
I see. All right. If a warrant has been issued, no further steps will be taken pursuant thereto till the next date.
Highly obliged, sir. Highly obliged.
Supplementary list item number 3.
May I please? It's a bail application, my lord. The offense under section 399 and 402, my lord. The petition is in custody since 22/8/2020, my lord. In the meantime, last occasion submit say the no prosecution has supported the prosecution of no story.
What are
Because all
instructions?
the
So I have received the case diary. In the meantime, the last week will come to page 26. The present petitioner is of Jharkhand. That is the reason why the learned session judge has rejected the bail application. And twice earlier, the previous bail application have been.
No, but now the changed circumstances, PWs have been examined and they have not supported the case of the prosecution. That was what he said last
I
time.
have annexed all the accused person already released on bail by this honorable court.
Plus by the date on which the last bail application was withdrawn, that was 11 February 2022. And all the orders
Just see the last order. On those two aspects, you have to give, they have to take instructions.
Because that instruction I have not received regarding the witnesses examined.
That's what you have to take instruction on, sir. One is that have all the co-accused been released on bail? Are you aware of that?
Yes, that was available by the next date.
All right. All right, but this first part that none of the PWs have supported the case of the prosecution. What about that?
Neither has avoided nor has given any documents. He should have.
No, last time he said it and that's how I recorded it. You have the depositions.
But it is not with me, but
how do you simply make a statement that there are depositions? How will you find out?
Because it's in custody, because petition is in custody and
no, it's happening in the trial court. The trial court lawyer should be able to get copies of the depositions.
I understand, but I have filed all the bail applications that is next to 3.
Sir, we are on the point that none of the prosecution witnesses have supported the prosecution. We are not on the co-accused bail.
I understand.
And all where are these depositions?
Last occasion, you will say give direction to the Mr.
He wants to see the deposition. Without it, he can't take instructions.
No appointments, even no the bail application.
Yes.
Nothing. And all those orders, whatever my learned friend is showing, those were available by the time when the last application was withdrawn.
Counsel, the applicant states that he will obtain copies of the depositions of the PWs and give one set to the learned AG within 2 weeks. Sir, now the latest Supreme Court judgment is we are supposed to dispose of bail applications within 2 weeks.
I understand, my lord.
So you file a fresh bail application.
Kindly say annex of 3, my lord. In spite of antecedent, other accused person already released.
So you're not answering the point. You're going to some other point, right? You made you made 2 points last time.
Yes, sir.
1 point today you're giving up. You're only harping on 1 point about co-accused bail. You submitted a point that none of the PWs are supporting the prosecution.
Yes.
Now you've given up that point.
No.
If you have not given up, you have to make good that point.
Kindly see the last order, my lord.
Sir, the order is the proof of PWs.
Your order.
Sir, is my order proof that the PWs did not support the prosecution?
Yes. No. You are to give
what are we talking? Where are the PWs?
Give direction to the.
Sir, do you want to produce copies of the depositions or you do not want to produce?
Because it is not with me. For that reason, I submit that you will say last occasion give direction to the Mr. Katkiel and RGA, take instruction on this regard.
He sought time for instruction. There is no direction. He only sought time for instruction, sir. Anyway, if the counsel the petitioner is permitted to.
I pray, my lord.
Sir, if you are not prepared to produce the depositions, we are not going to consider this bail application.
I pray one thing, my lord. Already he is in custody since 2020. and it is about to, I pray on the printer withdraw with the liberty to move with the court below.
Already, your counsel for the applicant seeks to withdraw this petition. We move the court below for urging the ground that, for urging for a fresh consideration of his plea for bail on the basis that none of the PWs has supported the case of the prosecution and that the other co-accused have already been enlarged on bail. All right. Dismiss is withdrawn with liberty is paid for. All right.
Supplementary list item number 4.
May I please receive matter. By last order dated 23/6/20 and my lord has granted liberty to me after the trial court at the stage of charges matter. My submission that by till date no charge is submitted, only waiting for the chemical examination report matter. I have about in the paragraph 13.
The petitioner has committed rape on her niece, who is mentally retarded.
You want to withdraw this and wait for that, sir? Better you wait for the FSL report then. Counsel, the petitioner seeks leave to withdraw this petition
My targeted
with liberty to approach the trial court after the report of the FSL is available.
may I pray one thing, my trial may be targeted.
Sir, without FSL, how will trial be conducted?
It's pending since 2 years, matter.
Whatever, the trial court will have to pass orders for that. Dismiss is withdrawn, dispose of is withdrawn with liberty is paid for.
Obliged.
Item number 5.
My lords, I'm appearing for the petitioner in this matter. I
Yes.
would like to apologize, my lords. that the
Requisites not filed. Requisites were not filed. Sir, there is a standing order by the Supreme Court that all these petitions have been disposed of within 6 months, I think. If you
Well,
keep
I
delaying
understand.
it, then we'll have to simply dismiss it.
My lords, I'll explain my difficulty. my
Despite an
lords.
order passed, despite notice having been issued way back on 6th April, May 2022, requisites have not been filed. As a last opportunity, fresh notice be issued, returnable. 9 September.
My lords, a fresh wakalatnama of Mr. Abhishek Dash has also been filed. If my lords may just take note of that, my lords.
Anyway, the registry will take note of it. Yes.
Supplementary list item number 6.
Defect removed within 1 week, my lord.
Defects, counsel for the petitioner states defect will be removed within a one week.
6, 7, 8 also same.
Okay. Or list on 29 July.
Item number 9.
Item number 9, your lordship, the requisite has not been filed yet. Your lordship, in the course of the day, will file the
Same
requisite.
order as in, okay, same order as in 5. Same date.
Obliged, your lordship.
Supplementary list for admission item number 10.
Item number 10, I am for the petitioner, my lord. The lordship has
Sir, I am for the
started with
respondent, my lord.
mediator. Only the joint affidavit has to be filed before the mediator because we have amicably settled between the dispute has been settled.
All right, then this matter can be disposed of.
Lord,
Is there a-
Lordship may kindly see flag D on your Lordship's record. That is the report of the mediator.
Right.
And Lord, I am in sync with your Lordship, Lord. It can be disposed of. There's nothing
All right.
pending.
The court has produced the report dated 30th July 2022 of the mediator, which notes that the parties have amicably settled their
But
disputes.
affidavit is not filed, my lord, the joint affidavit.
And they are directed to file a joint affidavit. Full stop. The joint affidavit we filed. When will it be filed, Mr. Das?
My Lord, his client's mother has been unwell, so I am ready anytime.
Next week, my lord, 21st.
Be filed on or before 21st July. List on 22nd. All right.
Obliged. my Lord.
Supplementary list item number 11.
My lord, I'm seeking permission to appear for the petitioner, my lord.
My lords, I appear for the respondents. I have filed my wakalatnama today. 2 weeks time may be granted to file.
Or a counsel, the respondent seeks and is granted 2 weeks to file a reply, rejoined up for the next date. 2nd September.
Deeply obliged.
Supplementary list item number 12.
Item 12, my lord, we are for the railway, opposite parties. Already obtained instruction, let me keep some time, then I will file the reason. Counter repeat.
Mr. Party appearing for the railways seeks and is granted 2 weeks time to file a reply, rejoined up for the next date.
Obliged.
2nd September.
Supplementary list item number 13.
Your lordship may come to page 11, the agreement. Page 13, 8, clause 18.
Who's for the other side?
May I please your lordship? I am for the opposite party number 1 and 2, my lord. Today I am filing counter in this case, my lord. Your lordship.
You're opposing the appointment or agreeing?
My lord?
You're opposing the request for appointment of an arbitrator or you're agreeing?
No. I am opposing, why I am opposing, my lord, from 2013, the agreement period has already been expired. Your lordship kindly have a glance, page 19.
All right, you
My
see the
com-
reply filed by opposite parties 1 and 2.
and
Your
talking-
lordship may kindly
Today.
see. Your
So you want to see the reply and file a rejoinder or we simply?
no. They
Ah.
have, they have accepted that agreement and your lordship may
You've
kindly.
got a copy of the counter.
My lord,
You have a copy of the counter.
no.
Without seeing counter, why are you arguing, sir?
Okay.
The counter affidavit of opposite parties 1 and 2 is taken on record, rejoinder filed for the next date. It's on 9 September.
Supplementary list item 14.
My lord, I am appearing for the opposite party. I have already filed my counter, my lord.
Here, my lord, they are disputing that it's not arbitrable. Now, in view of these recent judgments, that has to be left to the arbitrator. So if they have a serious objection to it, then we'll argue, but it's covered by Rubbing Electricals 2021
Lord,
SEC.
it is covered by your lordship judgment also. I'll show that. Yes, my lord. Let's keep it out some other date. I'll give judgment, some judgment. And
All right. If you can
September-
share those judgments, I'll.
All right.
I'll give. September, my lord.
Counter has been filed by the opposite party MCL opposing the request for appointment of an arbitrator. On the ground that there is no arbitration agreement.
No,
the dispute is not covered.
There is no contract, my lord. On the ground of there is no contract, at the stage of letter of intent, tender has been.
That there is no contract containing any arbitration agreement. All right. Rejoinder, do you want to file?
Yes, we'll file it.
Rejoinder be filed for the next date. List on 16 September.
Supplementary list item number 15.
15 minutes, I am for appearing for the respondent. I pray for 2 weeks time to file counter.
Okay. Mr. Devraj,
Because similar issues pending
Simpson
for
has
the
granted 2 weeks time to file reply, rejoinder for the next date, 16 September.
Supplementary list item number 16.
Well, I am for the petitioner. This is a dispute between the insured and the insurer towards the settlement of claim.
No, who's for the other side?
My lords, I appear for opposite party number 1
Just
and
see the cause list. This cause list, paper cause list. You find the name of this petitioner is not indicated. No. Name of the petitioner is not indicated. No, just make a note of it.
My lords, I appear for opposite party number 1 and 2. We have no objection to the appointment of an arbitrator.
You want to file a reply or?
No. We do not want. We have no objection to the
You have
appointment.
no objection. All right.
My lord, just 1 point. They've made opposite party number 2 the circle head as a party to this arbitration proceeding. If you see the contract, he's not liable for any claim.
All right. Yeah. Opposite party number 2 is delete the array of parties. Counsel appearing for the opposite party has no objection to appointment of an arbitrator without prejudice to the rights and contentions on the merits of the claim of the petitioner. What is the claim, sir?
The claim, my lord, the claim is there is the liability has been admitted by the insured.
Amount, sir, what is the amount?
The amount they offered to settle with 13,27,900.
We'll have an advocate appointed.
Yes, my lord's fourth schedule and under the aegis of the Orissa High Court arbitration.
Sorry? Yeah.
And my lords, it is my duty to point out.
Yes.
My lords, if you see the arbitration clause, which is at page 28. So the clause, the way it is worded, if the insurance company would have repudiated the claim as a whole, then the arbitration would not have been maintainable. But since we have not repudiated, arbitration will be maintained.
My lord, so far as the deletion of the petitioner opposite party number 2 is concerned, the policy has been issued from the office of the opposite party number 2.
Anyway, sir, we're not, this is not the stage for arguing merits. The court appoints Sri KMH Niyamati, advocate as sole arbitrator to adjudicate the disputes between the parties. The arbitration will take place under the aegis of the Arbitration Center of the High Court. All right.
Supplementary list item number 17.
Item number 17, my lord, I am for the opposite party. I pray for 4 weeks time to file a counter in this matter.
All right. Counsel to the opposite party seeks and is granted 4 weeks time to file reply rejoinder for the next date, 16 September.
Deeply obliged, my lord.
Special list. Special list for orders, item number 1.
None appears dismissed and non-prosecution. The interim order is vacated. Copy of this order be sent forward to the concerned court.
Special list item number 2.
Same order.
Special list item number 3.
Same order.
Special list item number 4.
I will raise all the points, my lord, at the time of my lord. At the
All right. Counsel to the petitioner seeks leave to withdraw this petition with liberty to urge all the points raised in the present petition at the appropriate stage in the trial court. This
Special list
post
item
is
number,
withdrawn with liberty is paid for. The interim order is vacated. Copy of this order be sent to the court.
item number 5.
Same as 1 and 2.
Special list item number 6.
Again, same.
Special list item number 7.
Same order.
Special list item number 8.
Same order.
Item number 9, my lord, I have raised all.
Item 9.
Ah.
Item number 9. Ma'am. Item number 9.
9. No.
Here I have challenged the order of public interest. One of the offenses is 3 SCST Act. That, my lord, the question that the incident took place inside the chamber of the
Public view, private view.
public view. That point I have taken.
Where is that?
The petitioner is a doctor. So Lordship will kindly see the complaint petition at page 13. Page 12, my lord, the complainant went to the CSC.
You are there for the legal aid.
Lordship, I am appearing for the appellant,
Opposite party.
Two. Lordship, I will take instruction. I pray for time, Lordship.
All right. Miss so and so appears for the opposite party number 2. Last time we had appointed her and prays for some time of instructions. Miss Mahapatra, on the other hand, refers to a judgment dated.
Judgment I have not got.
You have to give her. She has to examine it.
Yes, yes.
All right. Then stop it at that.
There are, my lord, several topics for judgment myself. I will.
Just give her some.
Also a copy to me.
Thank you.
Mr. Katke also.
Well, I will give the reference to my lord and the counsel for the statement. I will start the topic.
I'll get it. Okay. All right. From her, he'll get it. All right. 26th August. 26th August.
Interim order is.
Interim order to continue. All right.
Special list item number 10.
Number 10, my lord, parting of the criminal proceeding, my lord. Offense are under section 13 to reduce section 31 of the PC Act, my lord, and 120 of the IP. My lord, allegation is that there is a misuse of official position and undue favor to the executor in the registration of a document, my lord. My lord, allegation is that petitioner did not follow the guideline while admitting the document for registration in absence of checklist 2, which causes loss of the government money. My lord,
all these points you can urge in the trial court, sir.
My lord, as per the norms and principle for registration of the registering officer is to admit the document first, my lord, irrespective of his valuation. And there is, and my lord, if there is any deficit on the stamp duty, then the registering officer will forward the same to the stamp collector for the determination and realization of the deficit.
Which is this item, sir? Which one are you arguing?
My lord, item number 10, my lord. Item number 10, my lord.
1 minute. Sir, all these points you can urge in the trial court, sir. We permit you to do that. Permitting the petitioner to urge all the points raised in the present petition, the appropriate stage in the trial court, the petition is disposed of. The interim order is vacated. Copy of the order be sent to the concerned court. Honor.
Item 11. Special list item 11.
My lord, I am for the opposite party here.
Yes. All right. None appears for the petitioner dismissal non prosecution. The interim order is vacated. Copy of the order be sent to the concerned court forthwith.
Special list item 12.
Same order.
Special list item 13.
Same order.
Here the question of jurisdiction has been raised. Courts have no jurisdiction to decide the matter in view of section 154 of the Electricity Act. It's only the special court who is to decide, my lord. That's why the case is pending. And the government has made notification not making the sessions court Parla Committee as special court. That is the only question.
Lord, the case, the special court has been constituted and the case must have been transferred to the.
Must have been.
It's been constituted, you get transferred. He says it's been constituted.
Present proceeding is to be passed, my lord, because you have no jurisdiction either to take cognizance or to proceed with the case.
No, as per section 154(2), my lord, I may permit to read, my lord, where it appears to the court in the course of any inquiry or trial that the offence punishable under section 135 to 140 and section 150 in respect of any offence that the case is one of the tribal by the special court constituted under the act for the area in which such case has arisen, it shall transfer such case to such special court, my lord.
Correct. So the cognizance order has to go. That's what he's trying to say.
Cognizance is taken by the SDG. That is to go as well as the trial, my lord. This court.
So the cognizance will be taken by the special court. That's what he says.
Yes, madam.
You say counsel appearing for the opposite party number 2 informs the court that now in Parle Committee,
when the case is committee
a special court already stands constituted for electricity matters. Full stop. In that way, the matter, the impugned order dated
Page 21, 22/9/2012.
order dated
Running page 21. Order dated 22/9/2012.
order dated 22/9/2012 passed by the SDJM Parle Committee.
Yes.
Taking cognizance of the offence against the petitioner.
No, that is not right. I'm just doing lawsuit. Lawsuit for 22/9/2012. But the said offence is tried by the Court of Special Justice cum Session Judge, Parla Committee. And this record needs to be committed to the Court of Special Justice cum Session Judge, Parla Committee.
So no, there's no order taking cognizance, sir.
Yes.
Where is it? So it simply is committed to the court of the sessions judge, that's all.
When the
1610.
case is tribal, my lord. The language is tribal by the special court, my lord.
No, there is no order taking cognizance.
Page 2, where running page 13, my lord. Running page 13. The order begins page 12, annexure 1, 14/7/2027,
All
2010.
right. The order dated 27/9/2010 passed by the SDJM Parliament, taking cognizance of the offence under section 135 of the Indian Electricity Act 2003 against the petitioner is hereby set aside. As already noticed in the order dated 22nd September 2012 of the SDJM, the said case, that is arising out of FIR number 40 dated 13th April 2010, corresponding to GR number 131 of 2010, ought to have been transferred to the Special Court for Electricity Matters. Stop. It is accordingly ordered that if the said case will now stand transferred to the Special Court for Electricity Matters in Parliament and will be listed there on 5th September 2022, on which date the petitioner will appear.
No, she is suffering from cancer and being treated in Bangalore hospital. She's a lady. It's impossible to come.
All right. On which date her authorized representative of the advocate will appear.
You file a petition there.
Yeah.
Yes.
And the special court
An
will take-
appropriate application may be moved to exempt her from appearing on medical grounds.
Right.
The petition is disposed of in the above terms. A copy of this order be sent to the concerned Special Court for Electricity Matters, Parliament. Forthwith.
Maybe the special court may take cognizance and proceed in the matter, my lord.
We don't have to say that, sir. We just say we will proceed in accordance with law. All right.
My lord. My lord, my appearance for OP number 2 may be noted, my lord.
Yes, please. Yes.
Specialist item number 14.
None appears dismissed non-prosecution.
Item number 15.
Item number 15 and 16 will also may permit me
To withdraw on
raise
all the place. Okay. Counsel, the petitioner seeks leave to withdraw the present petitions. And with liberty to urge all the pleas raised here before the trial court at the appropriate stage. Disposed of is withdrawn with liberty is paid for the interim order vacated.
Specialist item number.
Yes.
Item 17.
My lord, 1 week's time, my file is missing, my lord.
No, sir. If it's missing, it's missing. You say,
My lord, next week, my lord, I have
no,
ready
sir, there's nothing in this. All these are usual matters.
only 1 week, my lord. I am arguing.
It's all right, except we're permitting all of you to urge the pleas at the appropriate stage in the trial court. The same order here. You say permitting the petitioner to urge all the pleas raised in the present petition, the appropriate petitioners to raise all the pleas raised here at the appropriate stage with the trial court. The petition is disposed of, the interim order is vacated. Copy of the order be sent. Yeah.
Specialist item 18.
None appears. This was non-prosecution.
Specialist item number 19.
Item number 19, my lord, I am for the opposite on behalf of.
None appears. This was non-prosecution.
Specialist item number 20.
Interim order is vacated. None appears. Dismissed non-prosecution. Interim order is vacated.
Specialist item 21.
Permitted to withdraw, my lord.
Counsel, the petitioner seeks leave to withdraw with liberty to urge all the pleas raised here at the appropriate stage in the trial court.
Item 21.
Disposed of is withdrawn with liberty is paid for.
Item number 21.
Dismissed for non-prosecution.
Specialist item 23.
Item 23, in the meantime, it has been settled, amicably settled, my lords.
You withdraw this.
Only, my lords, there is a NBW against me. That is why I am, if that will be recalled, I will pursue the lower court for closure of the case, my lords. I have given the money. It is arising out of 138.
No, some statement has to be made, sir. Where is the affidavit statement? Something has to be there.
I will file affidavit.
Counsel with the petitioner claims that all the disputes have been settled. He states that he will file an affidavit of opposite party number. Opposite party before the next date. List on 2nd September, interim order to continue.
Specialist item 24.
May I please, Your Lordship? There is a complaint case, my lord. And the so far the allegation in the complaint case is that, my lord, simple limited question, my lord. While the, my lord, this past panchayat election in the year 2012, the present petitioner who was elected as a Panchayat Samiti member and elected as the chairman of the Raghunathpur block, my lord. he filed the affidavit so far the allegation is the complaint by one of the opponent political group PS member, my lord. He will not, he has not passed BA examination, my lord. Simply
He
allegation.
raised all the pleas before the court because that
Madam-
other person is not here before this court.
No, because of his past BA examination, how the complaint case is maintained?
You have to serve. Where is the other side?
Annex 4 series, your lordship have a glance to the Annex 4 series.
Where is the other side?
My lord, he has passed BA examination, my lord. I have annexed the document. Utkal mentioned he is.
Are you able to hear me, sir? Where is the counsel for the other side? Pass over.
Specialist item 25.
Item 25, liberty may be granted to or the point Lord put.
Same. Permit to be withdrawn with liberty to raise all the pleas at the appropriate state. Correct.
Specialist item 26.
May I please your lordship, the prayer for passment of convenience, my lord, proceeding, my lord. In this case, my lord, the FIR lodged under
What's the offense under, sir?
under section 363, 366A and 34 IPC, my lord.
Have you filed an affidavit of the other side?
In the 164 statement, my lord, the victim girl submitted mentioned that she, according to her own will, she played away with the petitioner, and as per my instruction, my lord, from last 2015, my lord, both are living as husband and wife, and in the meantime, the girl child have been.
All right. The statement of the opposite party number 2. Should you party here? Yeah. No, not opposite party number 2. The statement of the informant's daughter under section 164 of the CRBC has been enclosed as annexure 2. Full stop. In it, she states that she went away with the present petitioner of her own accord. Counsel the petitioner further states that both the petitioner and the informant's daughter have now married since 2015 and are living together as husband and wife.
To issue
The above contentions are not contradicted by counsel of the state. In that view, the matter, all proceedings in GR case number 688 of 2012 in the court of the SDJM Badrak are hereby quashed. Copy of this order be sent forthwith to the concerned court. The application is disposed of. The petition is disposed of.
Specialist item 27.
May I please your lordship? And in this case, the petitioner challenged the order dated 16/80/2013 passed by the MFC Bhubaneswar, my lord. In 16 case number 4638 of 2013, the offence is under section 138 of any act, my lord. But there is 86 days delay in filing the complaint petition, my lord.
All that you heard before the trial court, sir.
My lord, before taking.
So here, none of them is appearing. None of the other side is appearing. Unless you're prepared to pay them the check amount, they're not going to come forward.
No, my lord.
You might as well go before the trial court, sir.
I am ready to face the trial, my lord. But before condoning the delay, the Lord trial court should have first, he should have heard about the delay, condonation of delay, my lord.
Yes.
But without condoning the delay, he straightway issue process against the present petitioner, my lord, which is illegal, my lord.
Right.
So first of all, your lordship direct the Lord trial court, he should first hear the matter on point of delay, my lord.
But he has heard, just see that page 8.
My lord.
Order dated 16th August.
My lord, page 8 of the complaint petition.
You have filed a petition, sir, before this court. We are referring to page 8 of that petition.
Yes, well, I have stated that he admitted, the complainant admitted that there is 86 days delay, my lord. It is submitted that before entertaining a complaint petition, which is barred by limitation, and before issuance of process against the accused petitioner, the Lord trial court should have applied the judicial mind on the complainant's plea, seeking the condonation delay in filing the complaint petition under section 142A of the NI Act, and in absence of that, the same is liable to be passed by this honorable court, my lord.
We say from the order dated 16th August 2013, of the SDJM Bhubaneswar issuing process to the petitioner for issuing summons to the present petitioner for appearance. It is seen that on the issue of delay in filing the complaint petition, the learned SDJM has simply accepted the plea that when the limitation was about to be over, the complainant fell ill. Full stop. This cannot be the reason for condoning the delay in filing the complaint petition. Full stop. In that view of the matter, it appears that the SDJM is not really properly examined the issue before issuing summons to the present petitioner. Consequently, the order dated 16th August 2013 is hereby set aside. And 1 CC case 4638 of 2013 is restored to the file of the SDJM Bhubaneswar to be proceeded with afresh at the initial stage. Full stop. After examining the issue of limitation, appropriate orders will be passed afresh by the SDJM Bhubaneswar. The interim order is vacated. 1 CC case 4638 of 2013 will now be listed before the SDJM Bhubaneswar on 20th September 2022. A copy of this order be sent forthwith to the concerned court.
Specialist item 28.
Done up, please.
May I take the list?
Yes, sir.
The quashing of proceeding on the ground that the informant has lodged an affair against the petitioner that the wife of the petitioner has been kidnapped by the wife of the informant has been kidnapped by the petitioner. I have made OP number 2, the wife of the informant. I have categorically stated due to some family dispute between the informant and.
But there's no affidavit, nothing, sir.
I have made party also notice such.
Yeah, but no notice is gone. Nobody's appearing. One DK Sethi. He's for the state, sorry. JK Chotra is your for the state, is it?
Well, OP2.
OP2. No, Parvati Behra is OP2.
Yes, Parvati Behra.
So unless you file their affidavits, there's told to be no.
My lord, one council also.
Plaque K, I don't have the copy. Of course, there is a plaque K loss mechanical.
He has made a statement. You see the affidavit, Srimati Parvati Behra. Scan. Have you seen that affidavit, Mr. Katkia?
No, I have not seen it.
It's here. Just see it. Opposite party number 2 has filed an affidavit stating that she was staying in her relative's house on account of a dispute with her husband and that the petitioner is no way involved in the case. Stop. This affidavit is not disputed by counsel for the state. That view of the matter. GR case number 9 of 2014 pending the court of the JMFC bracket O Bhubaneswar and all proceedings consequent thereto hereby quashed. You see, in connection with Chandaka PS 1 of 2014 and all proceedings consequent thereto hereby quashed. All right.
Specialist item 29.
None appears. This is not prosecution.
Item 30.
Permit to withdraw my liberty.
All right. Counsel the petitioner seeks leave to withdraw the petition. Liberty to urge all the pleas raised here in the appropriate stage of the trial court.
Specialist item 31.
31. I may please your lordship. I am an VC. Here is a petition has been filed for quashing of proceeding, which was initiated in the 2013. In the meantime, 9 years, about 9 years elapsed. Both the petitioner as well as the victim have married to each other
Alright.
and lived a happy conjugal
Alright,
life.
counsel, the petitioner states that
Meantime,
both the
they have
both
left,
the
they have
petitioner
left
and
with a
the
son.
complainant, the victim have married, and the copy of the marriage certificate is placed in record. A copy to compromise petition is also being placed in record. These facts are not disputed by counsel for the state. Consequently,
They
all
have blessed
proceedings
with a
arising
son.
out of Ranapur PS case number 228 of 2013, 226 of 2013, corresponding to GR case number 224 of 2013, pending before the court of the JMC Ranapur, are hereby quashed. The petition is disposed of.
Obliged, highly obliged.
Item 32.
My lord, it's a my lord, family dispute between the family members. Anyway, my lord, after 8 years, my lord, there must be compromise. Your lordship may say that let them.
All right. Permitting the petitioner to urge all the pleas raised in the present petition the appropriate stage in the trial court. The petition is disposed of. The interim order is vacated. All right.
Specialist item 33.
33, my lord. Your lordship may kindly have a glance at the my lord, 164 statement, which reveals that the victim girl had voluntarily gone to the house of the petitioner, and thereafter she has given a statement that after 18 years, after attaining the 18 years, my lord, she will marry the petitioner, my lord. My lord, the other side is also
All right.
appearing
The
somebody
statement of the
appearing.
victim under section 164 CRPC stating that she went of her own to the petitioner's house is placed on record. It is not disputed by counsel of the state. In that view, the matter. FIR number. The FIR in Denkanal Sadar PS case number 35 2014, corresponding to GR case number 19 2014, and orders in consequence thereto. I hereby quashed.
Item 34.
None appears dismissed and non-prosecution.
Item number 35.
Though the matter is relating to the year 2013, but still now no charges were framed. And I will raise all the points at the time of framing charge.
Permitting him to raise all the issues raised here in the appropriate stage, the trial court. The petition is disposed of.
Item 36.
Immediately on VC, my lord.
May it please the lordship. May it please the lordship. My lord, this is an application seeking for quashing of the criminal proceeding, my lord, against the present petitioner on the ground that the co-accused persons are also acquitted, basing upon the statements.
So you can then apply to the trial court, sir. You say permitting the petitioner to urge all the pleas raised here at the appropriate stage in the trial court. The petition is disposed of. The interim order vacated.
Specialist item 37.
None appears dismissed and non-prosecution.
Specialist item 38.
Again, same order.
Specialist item 39.
Same order. Memos taken on record. The application is dismissed as not pressed. Interim order is vacated.
Specialist item 40.
None appears dismissed. Non-prosecution.
Specialist item 41.
My lord, it's a case and counter case for civil disputes. Practically, there are 3 affairs, my lord. So
no one appeared on the other side, sir.
My lord, one thing, my lord, since the civil judge, senior division Bhubaneswar has passed the order of status quo on dated 18/1/2014. For that reason, the affairs has been lodged. My lord, there is practically no disputes. Practically,
all this at the appropriate stage in the trial courts. Permitting the petitioner to urge all the pleas raised here at the appropriate stage of the trial court. The petition is disposed of. The interim order is vacated. All right.
Item number 42.
My lord, item 42. My lord, I have no instruction in the matter.
All right, counsel for the petitioner states he has no instructions. The petition is dismissed. Interim order is vacated.
Specialist item 43.
My lord. Yes, I have challenged the order, my lord, improvement order on the ground of territorial jurisdiction. My lord. The court has no territorial jurisdiction, try the offence. My lord. The alleged offence is at Cuttack, Buxware Cuttack. But the SDM sir.
See.
The complaint case was filed at Bhubaneswar SDM, my lord. And he has taken directed the police on 156(3) to cause investigation and your lordship, the complaint petition is page 10, your lordship may kindly see, running page 10. Is alleged clearly it is on, may I read me lord the allegations.
So it's a complaint case. Who's appearing with the other side?
No, it has been only the state has was given the.
No, it's there two private companies. OP2 and 3.
Admittedly, the alleged offence is at Cuttack, Buxware Cuttack, my lord. When the complaint case was filed at Bhubaneswar SDM, and only SDM has taken the directed the Kharwada police station to register the affair and proceed with the investigation.
Permitting the petitioner to urge all the pleas raised in the present petition at the appropriate stage in the trial court. The petition is disposed of. All right.
Especially, your lordship may kindly say the regarding jurisdiction, territorial jurisdiction also, your lordship.
Yes, yes, all points raised. Right.
Specialist item 44.
None appears dismissed from prosecution.
Specialist item 45.
In item 45, I am appearing for the petitioners. Now the counter has been filed as per the note sheet in the cause list, but the counter copy has not been served on us, my lord.
What's the matter about, sir?
Here, actually, it's purely a civil dispute. I am a businessman in operating out of Delhi, and the opposite parties herein are also businessmen in Bhubaneswar. So we had been having business relationship between 2003 to 2006. Now, a certain amount of outstanding was due from these opposite parties, for which I filed a suit at Delhi, and the suit was decreed in my favor in 2013. And after initiation of the suit and after they appeared before the trial court at Delhi, they filed a 156(3) 1cc complaint petition before the SDJM Bhubaneswar, basing on which the FIR was registered much after initiation of a suit. And the ground taken therein in the complaint petition was that they had issued us 5 checks, and we have suppressed this fact, and we are denying of having received these checks. So this is the whole story, and the suit has been decreed. They have went in appeal. Appeal has not been stayed, and the matter is pending before the Honorable Delhi High Court, my lord. And if your lordship will see, they say they have issued 5 checks. And if your lordship kindly come to page 42.
Who's the other side?
Lordship, I am for the opposite. Your lordship, file the counter. Your lordship, that the suit is different. Your lordship, once the case has been filed, and accordingly has been taken rightly, lordship. There is no illegality to take the accordingly, because I am giving the 5 demand draft which has been cleared by the bank, lordship. Have a glance at page 44 of the chassis, lordship. He said 4 or 5 demander has been cleared the name of the accused person, lordship. The suit is something different. That there is putting something different. Your lordship,
suit has been decreed against you.
Expert lordship. That was challenged.
No. Then what happened in that appeal?
That was still pending. That was not. Your lordship, criminal case something different. Suit is something different, lordship.
Let me just clarify, my lord. In 2010, the suit was decreed ex parte. Then against that, they filed a FAO before the Delhi High Court. The matter was remanded with the condition that they should be allowed to participate. In 2003, finally the suit was decreed on contest. And then again, they have filed an appeal. That appeal is pending. They deposited 50% of the decretal amount, and the matter is sub judice at present, my lord. And after initiation of my suit, my case is, after initiation of the suit, they have filed this FIR on 156(3). And the interesting part is, if you also will see page 42 for a moment, they have given the details of the 5 DDs amounting to this 2,49,000. And the DDs have been issued in favor of some third parties. My name is not reflected in the DDs. By taking this plea, they have gone and filed an FIR under 420 of IPC, and the police, without proper investigation, police has never called me for the investigation. Neither they have visited my office at Delhi, and they have filed a charge sheet. Page 42 and page 44 clearly states that the DDs were never issued in my favor, my lord.
Look, 40,
That is my whole
44,
story.
your name is there, Lordship.
Purely as a count of
44 is his name is there. Have a glass.
kindly 44.
44.
Your Lordship, kindly see page 44, my lord.
Just that chassis. You also 44 is name.
No,
Lordship.
first let us see the page 44.
Sunil Nitin Lordship.
Sorry?
Lordship, Sarad, Sunil Nitin Lordship. 4 person name is there, Lordship. Have a glass, Lordship. My complaint case in page 36, Lordship, I have clearly stated that, Lordship, the Manchester Industrial State have advised the complaint that in his name, the two demand drafts, rupees 49,900 rupees, 900 only be prepared, and in the name of his brother Sunil name is there, Lordship, two demand draft. And are the prepared in the name of the Nitin Sunil name is there. Have a glass 44, Lordship. Nitin Sunil name is there. So rightly the demand has been
Only Sharad's name is there.
Sharad last is Sunil Nitin there.
May I just clarify, Lordship, kindly see page 42 and 44.
Amount are also clear, Lordship, by the bank.
Let me just finish.
Obvious.
Kindly see page 42 and 44. The name of my firm is Seal Electronics. All business transactions have been done in the name of my firm. Now, the DDs have been issued in a nickname Sarad.
That at the time of the trial, it will be proved. All these things also at the time of trial, it will be proved.
And this is nothing but a counterblast, my lord. After this, everything has happened only after my filing the suit. And they say these DDs were issued in 2004, my lord. What were they doing till 2008, 2007?
Right. What is the explanation of the delay?
Lordship, I am filing this complaint case, Lordship, in the year 2008, Lordship.
So what's the 4 years delay?
That was, Lordship, after knowing that, Lordship, because one Lordship, the amount has been cleared by the bank, Lordship. But 2007, Lordship, amount has been cleared.
Cleared? What will it's not cleared, sir? That's why we filed the complaint. You filed the complaint because not cleared.
That is a delay, something different, Lordship.
What is different?
I am the trial, Lordship, it will all these things.
No.
I'll also file the counter, Lordship. I have stated all these things, Lordship.
So the DDs were dated of 24th April 2004, and they filed the FIR in 2007 September. We sued in 2007 March, my lord. Only after appearing in the suit, they take this unique stand, my lord, as a counterblast.
That is different thing. Suit is different thing. Here, Lordship, something different. Your criminal case, suit is civil, Lordship. Sir, as a criminal case, that suit is Lordship for the.
No. You have to explain your delay in filing a complaint against this demand drafts being dishonored. The demand drafts are of 2004.
Lordship, one more chance may giving, I will.
No. What is that one more chance?
I just going to, Lordship.
No. In your reply, do you have any explanation? Is there any explanation? Is the reply?
No, my lord, nothing.
All right. The application is allowed. I'll pass the detailed order.
Obliged, my lord.
Specialist item 46.
No, please, it's not.
Specialist item 47.
No, please, it's not.
Specialist item number 48.
This case, I have my file has been misplaced. I may prefer 1 week to prepare.
No.
Yes,
Once the petition says file has been misplaced, the petition is dismissed for non-prosecution.
Your Lordship may pass it.
Pass it over.
Your Lordship may dispose of it with the regent order.
All right. Permitting the petitioner to raise all the pleas raised in the present petition at the appropriate stage before the trial court. The petition is disposed of. All right.
Item 49.
None appears this is not prosecution.
Specialist item number 50.
Petitioner trying for passing of a criminal proceeding in view of the marriage between the petitioners, my lord.
Where is that?
Next one is fair Miller, offense under section.
No, where is the statement? Where is the marriage certificate?
Marriage certificate, not next, but birth certificate of my.
Not birth certificate, sir. Where is the marriage certificate?
Marriage certificate.
Permitting the petitioner to raise all the pleas raised in the present petition at the appropriate stage, the petition is disposed of. All right.
Specialist item 51.
May I please, Your Lordship? In this application, my lord, I am challenging the order framing charge against me, my lord, against the petitioners under different sections, including 304A and other offences, my lord. Other are minor offences and 9B of the Explosive Substances Act, my lord. What has happened? There is a clear mistake of facts, probably. And the learned court below has not at all considered it. My lord, in the FIR, if your lordship will kindly have a glance, my lord.
What is the offence, sir?
The offence is 304A, Rash and Negligent Act, my lord, causing death of a person, my lord, of a lady, my lord. That is the allegation, my lord. What has happened, my lord? The petitioners are the employees of one BBSR Construction Private Limited, who has undertaken a execution of a road work, my lord, being authorized by the government of Orissa, my lord. My lord, while the, my lord, for the purpose of my lord, that construction work, a quarry lease was taken, my lord. The quarry was taken on lease for my lord, that collect boulders, my lord, for the purpose of construction of the road, my lord. On the particular day, that is on 31/3/2012, there is an explosion. My lord, with the permission granted by the collector, the explosions were being made to my lord, extract the boulders, my lord. My lord, there was an explosion.
And how this can't be examined in this petition like this, sir?
No, my lord, here is a case your lordship will find, my lord. There is a clear case where they have admitted that she has died due to
Here there has to be a contest. You are saying the admitted is neither here nor there.
My lord, state is there, my lord. State is the other side. State has taken up the state is the informant here.
Yes.
The sub-inspector of police has informed, is the informant.
Yes.
No private person has. My lord, the sub-inspector, if your lordship will kindly turn to page 13. Your lordship will find the allegation is that a construction company in the name of BBSR Construction Private Limited has established.
You can raise the appropriate.
Why he will unnecessarily, because they are doing the duties and for construction works in different places. They will be unnecessarily dragged into, because the son of the deceased, the two sons of the deceased, they have specifically said in their statement that she has died due to pain in the chest, my lord. And here is a case, she has received an injury in the leg. She was taken to the hospital at Visakhapatnam by the petitioners, my lord. There they took the deceased to their village, my lord. The injured deceased to their village. After 2 days, she complained some pain in the chest.
So we are not going to go into the merits like this. This is not the stage for doing all that.
So, my lord, it is not on merits, my lord. I am saying, my lord, in the FIR, a wrong thing has been narrated. Your lordship, that is why I am taking your lordship's kind attention to the FIR. Your lordship, kindly give me my lord, 5 minutes time, I will satisfy your lordship, my lord. My lord, the construction company in the name of BBSR Construction Private Limited has established an integrated automatic crusher unit at Venkatpuram under so and so. The company is executing the work for widening the road, that is SH4, State Highway, number 4, from Parnakhamundi to Gurupur under LWE scheme through another construction firm, namely B. Ramanaya Construction. The company have established a camp at Venkatpuram near their crusher plant and also running their office, kitchen and some staff quarters at the same place. One old lady, this is important, one old lady, namely Sodipalli so-and-so, age 38 years, daughter of so-and-so, was staying in the adjoining cashew field in hot along with his stepson and collecting cashew nuts from the cashew field taken on lease from one doctor so-and-so of so-and-so since last 2 months. The lady had access to the camp office of BVSR BRC and sometimes takes meal from the kitchen. Not further, as per the available copy of the documents, it is ascertained that one Anni Gopal Rao of Gola Khanja Street, Parlathamundi, had taken a lease of a stone quarry by Venkatpuram Stone Quarry number 3 and on the Visakhapatnam Hills in plot number so and so for operating quarry and providing the stone boulders to BRC crusher unit. The quarry site is located within a distance of 300 to 400 meters from the camp office. He had obtained the blasting permission from the collector. Permission was there, my lord. From the collector Gajpati valid up to 31/3/2012 and to utilize explosive in operating the quarry through one Jete Mishra, holder of class 2 managing certificate, procuring the explosive from so and so, so and so. Further, the quarry owner has also been permitted to the director safety mines, so and so. Those are safety measures were taken. All the activities were managed by so and so. The BVSR BRC is the sole responsible for every omission and commission at the camp or work site. On 18/4/2012, the occurrence took place, my lord. At about 5 p.m., there was a massive blasting at the Venkatpuram Stone Quarry number 3, reportedly operated by the people of BRC through their blasting agency. Due to such explosion, stone boulders were scattered and fell around the place, including the camp office of BRC. By that time, the above lady, the deceased, my lord, so and so, was inside the kitchen. Due to impact of explosion, a piece of blasted stone pierced inside the tin roof and hit the right leg of the victim lady, so and so, thereby caused fatal injuries on her person. She was immediately shifted by her stepson on the direction of the employee of BRC in their vehicle towards Visakhapatnam for treatment. It is ascertained that the lady expired on the way near Srikakulam, which is not a fact at all, my lord. After 2 days, she expired, my lord. My lord, the employees BRC, then, my lord, the allegation goes, my lord. Now, if your lordship will kindly come to the statement of the son of the my lord, deceased, namely Chintala Naveen. My lord, he says, of course, it is in vernacular, my lord. He says that from Visakhapatnam, he and his brother both took the deceased to their village, my lord. 2 days she was all right, my lord. After 2 days, suddenly she felt pain in her chest, my lord, and thereafter she expired. My lord, this is the statement of the son. But the FIR says while taking her to Visakhapatnam, she died. But the sons say, both the sons at page 15 and page 16, both the sons, page 15 and 17, my lord, both the sons have said that they took the deceased to the village. And in the village, after 2 days, she complained some pain in the chest. If I am not correct, my lord, friend is there, he may correct me, my lord. My lord, she complained pain in the chest, and thereafter she expired, and they my lord, cremated the dead body without sending it her to the for postmortem, my lord. Now, my lord, my defense is now closed because of their behavior, because they didn't send the my lord, the dead body to the investigation for postmortem to ascertain whether it is due to impact on the leg or due to chest pain, my lord. Because they have specifically said that after 2 days, she complained.
All this can be examined with the trial courts.
No, because my defense is not there. They themselves have cremated the dead body.
Right.
So where from I will get my defense now, my lord? All these things have to be considered by your lordship.
No, not here, sir.
No, because it was to be considered by the charge framing court, my lord.
Right.
The charge framing court has not at all applied its mind, has not gone into the, or else what I pray, my lord, your lordship may say, your lordship may remand the matter to the lower court, my lord, to consider all the statement and thereafter pass order for taking.
The court is not
charge.
satisfied any ground has been made out.
My lord,
Interfering with the order on charge dated March 2014 at this stage. It will be open to the petitioner.
Then your lordship may say, I may be permitted to, my lord.
Yeah, the
I will
petitioner is
give-
permitted to urge all the pleas raised here at the appropriate stage of the trial.
Yes, appropriate.
The petition is disposed of, the interim order is vacated.
Specialist item 52.
I may be, Pardon Lordship, I am sorry to interrupt Lordship, that item 44, your Lordship are asking for delay. I am explaining in my.
Not like this, sir. You can't wake up suddenly when I'm hearing the 10th matter. You forget some argument and you suddenly come in the middle and start. Sorry. Yes.
Item 52.
Item 52, I'm appearing on behalf of Mr. Ayadas.
Yes.
Lordship, may kindly dispose of the matter because we don't have any instructions in this.
Counsel petitioner has no instructions. The petition is dismissed. Interim order is vacated.
Obliged.
Specialist item 53.
Lordship, item number 53, my lord, we have challenged it. We challenged the FIR, which was registered after the 1cc case, my lord, the order. But my lord, may I kindly have a glance to page 86. This is where the FIR is, my lord.
Yes.
And my lord, may I kindly turn over the page. My lord, at 87 are the accused persons. And my lord, at 91, at the very bottom, I'll just take, I'll try and be as brief as possible, my lord. My lord, page 91 at the very bottom, the brief facts, my lord, may kindly have a glance. The complainant is the right title possession holder of the property situated in Moja Dis under Bhubaneswar Tahsil, plot number 7851240, decimals. My lord, may turn over the page, which the government has allotted on scheme of retired soldiers. That on 5/10/2013, my lord, may kindly have a glance. In the year 2013, the complainant is saying at about 11 a.m., while the complainant along with his son and other friends, relatives went to the spot for a measurement, he saw there were a number of hoardings in the name and style in which written Builders Consortium Director Jagannath Promoters, Dream Homes Limited. The complainant, being astonished, entered into the field and started measurement with a measuring tape in between the accused persons, gradually gathered, and there was a issue, my lord. Then it says thereafter they called the accused and the land is there alienated in their favor and so on and so forth. My lord, my short point is, in 2013, the complainant says that he so-called went into his land and there was a dispute. Now, my lord, may kindly bear with me, my lord. Since 2009, my lord, may kindly come to page 70 of your lordship's brief. My entire endeavor, my lord, is in 2013, he says he suddenly saw these people, the accused persons. Since 2009, he's been litigating with them, both civil and criminal. My lord, may kindly have a glance at page 70. He filed a 144 case, my lord, before the DCP, my lord. The learned DCP, my lord, may kindly turn over the page at 71. At the very bottom, 5 lines from the bottom, my lord. The DCP directed, IIC Khandagiri PS is directed to inquire into the incident and submit detailed report in respect of the scheduled property. Now, my lord, the report, my lord, may kindly have a glance. The report is there in page 80, my lord. My lord, may kindly have a glance to page 78, wherein the detailed fact was given. I'll just place those relevant portions. And my lord, may kindly note that it is in 2009, 4 years before the so-called FIR was filed, my lord. Page 78. The objection filed by second party, Srimali Urmila Patnaik, this, which is also supported by the interveners, revealed that the first party, which is the complainant, is not the owner of the scheduled property at all. Much prior to filing of this case, he has sold the scheduled property by plotting it into small plots. The first party has obtained permission from Tahsildar Bhubaneswar as such, and so sale deeds have been executed. The son of the first party demolished the boundary wall constructed by OP number this and this at the instance of this. The OP number filed civil cases since 2009, respectively against first party and his son, claiming permanent injunction and damages against them. The opposite party number 1 to have also claimed temporary injunction. Now, my lord, may kindly at the very bottom of the page, on verification of record and documents, it is evident that first party member obtained permission from Tahsildar
and sold those properties to the petitioner after obtaining permission. Now, my lord, may kindly turn over the page. At page 80, my lord, after the report from the Khandagiri PS had come in the very middle, my lord, considering the facts enumerated above, it is clear that the dispute lies on the possession of both the parties over the scheduled property, which is civil in nature, resulting in filing of a number of civil cases in the Court of Civil Judge Junior Division, Bhubaneswar, pending relating to self-same property, with ad interim injunction restraining the opposite party in the case. Since civil cases are pending over the scheduled property between the same parties and interveners over the self-same property, I am not inclined to intervene. Now, my lord, it does not stop there, my lord. Now, my lord, may kindly turn over to 81. I, who is a petitioner here, my lord, had filed a FIR against them, against the son of the complainant at page 81. The son, pursuant to this, my lord, had come and taken a bail petition. My lord, may kindly see page 81, Mr. Abid Ali petitioner, son of Syed Basar Ali. Now, my lord, turn over, it was given a bail. Now, my lord, may kindly have a glance at page 84. In the meantime, charge sheet has been filed by them. All is pre-2013. Now, my lord, he suddenly comes in 2013 and says, I don't know these people who are in the plot. I go there, they have, so my lord, my humble submission in the 1cc, he conveniently suppressed all these factual aspects, but that they were, are they appearing here? My lord, they are there, my lord, they have already appeared. Their name is also reflecting. I also have judgment, my lord, as your lordship knows, my lord,
We'll just pass it over once, let's see.
Grateful, my lord, grateful, I'll wait.
Special list item 54.
None appears to be not possible.
Item 55.
None appears to be not.
Item number 56.
None appears to be not.
Item 58. Item 58.
57, we see it's already adjourned, no?
Already adjourned.
It's 57 was adjourned.
Already adjourned.
Item 58.
None appears to be not possible.
Item number 59.
May I please? Here, my lord, the only question, my lord, to be decided, that whether in a complaint where offences are triable by Court of Sessions, Lord Magistrate has to make inquiry himself or can exercise power under section 156(3) of CRPC. But 202 of CRPC bars for so. Magistrate cannot, if the alleged offences are triable by Sessions, magistrate cannot invoke 156(3) CRPC to register, to direct the for registration of the affair and to carry out investigation. That is under Annex 2, your lordship.
What has the magistrate done here?
Magistrate, my lord, directed for registering the affair and to carry out investigation.
Where is it? Which is the order?
But Annex 2, page 12, your lordship.
Page?
Page 12. On perusal of the complaint petition, this court feels that the case should be properly investigated. Hence, in exercise of power conferred under section 1.
Cognizance taken. All right. This is only for SC/ST Act.
But the allegation was made under section 307, my lord. The cognizance has been taken on 3 SC/ST. And also, if it is 3 SC/ST, also magistrate has no power also.
The registration is not under 307.
307, it was.
No. Just read that order.
Yes, Annex 1. That is order of cognizance. That is subsequent. But if allegation is made which is triable by Sessions, magistrate cannot, my lord, invoke 156(3). But your lordship may kindly see Annex 1. And complaint petition, your lordship at page 7. That is under section 307. Investigation was made, charge sheet was submitted. Thereafter, my lord, it is 3 SC/ST. But it is prior to investigation, after the time of
no, but if anyway 307 is not there, then what's the problem?
Well, 3 SC/ST is also there. 3 SC/ST magistrate has no power, my lord, to take cognizance over the matter.
To challenge the present petition is to an order dated 7th August 2012 passed by the JMFC, sorry, Nimapada, taking cognizance of the offences, including under section 3 SC/ST Prevention of Atrocities Act against the petitioners on the short ground that cognizance under the above provisions of the SC/ST Act could not have been taken by the JMFC. but only by the special court designated to deal in such offences. The impugned order set aside. The 1 CC number 209 of 2012 in GR case number 778 of 2012 is now directed to be allocated to the appropriate court by the district judge. Which district is this? Puri.
No, my lord, the procedure is different. If it is, my lord, the alleged offences in the sessions court, then magistrate or law and session judge or special
Will
court,
commit it to that court.
no, you will not commit. You will call for the witnesses to be examined before taking cognizance. That is 202.
No, but it has to go before the concerned court, sir.
My lord, concerned court at the stage of, my lord, filing of the complaint, at the stage of complaint. Not that at the that investigation will go, your lordship. That can't be investigation.
We have
Only
set
my
aside
lord-
the order, sir. We have set aside the order. Now the complaint will go before the appropriate
Yes,
court.
at the stage of complaint, man.
So the district judge will allocate it to the appropriate court.
Yes, it-
That's
not
what
in the
I've said.
form of commitment, your lordship. May I beg to submit before?
I have not dictated anything on commitment, sir.
Obliged.
The matter be placed before the district judge for that purpose. On 2nd September 2020.
May please.
Resolution item 60.
Challenging the order taken in cognizance by the Annexure 3. The cognizance has been taken against 3 accused persons for an offence 323, 506 along with the other offences. And at the against out of 3, 2 accused persons are already acquitted by the Annexure 5. And in Annexure 4, there are diffusion of the injured informant. Yes, specific state matter has been compromised, and there is I have not received any type of injury. That is, kindly see page 40. First cross examination. The matter is decided in village matter to be compromised. The accused person could not attend due to cultivation. I am not interested to proceed the case. Thereafter, my lord, 5. The accused person have not dealt in Katua blow to me.
No, 1 minute. Which page are you reading?
The page, the deposition of Annexure 4, your lordship kindly see. PW1, the informant injured. Column 4. Cross examination, your lordship kindly see. Four and 5. Hello, got it?
Yes.
The matter is decided in village to be compromised. The accused person could not attend due to cultivation. I am not interested to proceed the case. Thereafter, my lord, the accused person have not dealt in Katua blow to me. It is not a fact. I have not sustained any injury. Since my lord, the matter already been compromised, and yet the other accused person already been acquitted.
All right. The present petition challenges seeks the quashing of the order dated 30th November 1998, passed by the
JMFC Digapandi.
JMFC Degapandi, taking cognizance of the offences against the petitioner arising out of in GR case number 291 of 1997, corresponding to
Injili PS case number.
PS case number 111 of 1997.
Yes.
In Hinjili PS. It is pointed out that of the 4 accused persons, 3 have been, the other 3 except the present petitioner. 4 accused, right?
Yes. No, the 3.
3 of the 3 accused, the other 2 except the petitioner have already been acquitted by the trial court. So opposite party number 2 is the complainant, has in his deposition in the trial stated that the matter already stood compromised between the parties and that he's not interested in pursuing the matter. The deposition as recorded by the JMFC Devapandi on 11 January 2002 is enclosed as Annexure 4 to the present petition. Paragraph. Although opposite party number 2 was served as at one stage was represented by counsel, today none appears on his behalf. Counsel of the state is unable to dispute the fact that the other two accused have already got acquitted on the statement of the complainant that there was a compromise between them. In that view of the matter, the order dated 30th November 1998 of the JMFC Devapandi and all proceedings in GR case number 291 of 1997 as well as arising out of the PS case number 111 of 1997 of Hingley PS are hereby quashed. The petition is disposed.
Specialist item 61.
None appears to dismiss and non-prosecution.
Item 62.
Same order.
Item number 63.
Memo is taken and record.
Memo.
Counsel
is
of
no
the petitioner
instruction.
does not wish to proceed in the matter. The petition is disposed of. The interim order is
Specialist item 64.
64, my lord, Mr. Mahanti is suffering from fever, my lord.
Let's
And
see what
taken
the
over
matter-
1 week after, my lord.
No, let's see what the matter is for. And urge all the pleas at the permitting the petitioner to urge all the pleas raised in present petition at the appropriate stage in the trial course.
Forging of some court orders.
The petition is disposed of. The interim order is vacated. Same in the next matter.
Item 65. May please, Your Lordship.
My lord, on the basis of the FIR lodged by the informant, Annexure 1, the FIR was lodged for commission offence under section 457, 323, 354A, 506. Kindly have a glance to order dated 39/2013, running page 14, my lord. The petitioner was arrested and released on bail, my lord. Then, my lord, kindly turn to running page 18. Order dated 9/10/2013. I am placing the complainant file application before the APP to cancel the bail application already granted to the petitioner, my lord. APP filed the cancellation application. I am placing the order. The case record is put up today for order on the petition filed by the London APP on behalf of the complainant. In the meantime, I have submitted report regarding activity of the accused Prafullo Behera, son of so-and-so. In her report, IO stated that after due inquiry, she found that on 5/10/2013, during morning hour, accused abused the father of the victim, Vishwanath Behera, threatened with dire consequence. On 5/10/2013, complainant was very much present in the court and also alleged that accused terrorized them and abused in absolute word on public road and humiliated them in public. Peruse the case record, petition filed on behalf of the complainant, inquiry report of IO, and bail order dated 30/7/2013. After perusal of the case record and hearing the parties, it revealed that the accused violated the terms and conditions of the bail bond. He was released on bail on the condition that he will not commit similar type of offense. He shall not threaten the witness in any manner, and if violates such condition, the bail bond will be cancelled. In the instant case, the accused violated the terms and condition of his bail bond. Hence, bail bond furnished by the accused on 30/7/2013 is hereby cancelled. Issue envied, my lord. My lord, in the case of Daulatram case, Honorable Supreme Court had decided the ratio. Once bail granted, should not be cancelled automatically. Overwhelming circumstance required. Kindly have a paragraph 4, my lord. Paragraph 4. Very cogent and overwhelming circumstances necessary for an order directing the cancellation of bail already granted. Generally speaking, the ground of cancellation of bail, broadly illustrative and not exhaustive, are interference or attempt to interfere with the due course of administration of justice, or evasion
or attempt to evade the due course of justice, or abuse the concession granted to the accused in any manner. The satisfaction of the court on the basis of material placed on the record of the possibility of the accused absconding is yet another reason justifying the cancellation of bail. However, bail once granted should not be cancelled in a mechanical manner without considering whether any supervening circumstances have rendered it no longer conducive to a fair trial to allow the accused to remain his freedom by enjoying the.
But the complainant did make statement in your case, sir.
My lord,
Being threatened,
no FIR laws.
publicly humiliated.
My lord, no, in that respect, for subsequent occurrence, no
You
FIR
can't say
laws.
there's no material before the court to cancel the bail.
My lord,
You cannot say there's no material before the court to cancel the bail.
yes,
sir.
my lord, there is no material because no
Statement of the
FIR.
complainant is there, sir.
Complainant, my lord,
Accused the father of the victim and threatened with dire consequences.
for a occurrence, one FIR is
And
necessary.
again, the court alleged that the accused terrorized and abused in obscene words in the
For
public
that-
road.
My lord, for that purpose, one FIR is necessary. Without a FIR, once the bail granted,
This judgment doesn't say there must be an FIR.
no, overwhelming circumstances necessary. Once the bail granted, it cannot be cancelled automatically without.
It is not
affecting-
automatic, sir. Detailed order is passed. It's noted that you've been threatening the witness, the victim. It's not a mechanical order at all.
My lord, for that purpose, one FIR is necessary.
That
Without a FIR,
where is the law saying if there is no FIR, you cannot cancel the bail?
Yes, my lord, I will show my lord.
No. There's nothing like that. Don't
This is the
simply-
principle, my lord, once bail granted for over a region necessary,
Yes,
my lord.
the court, the petitioners agreed by an order dated 9/10/2013, cancelling the bail granted to him.
And the petitioner is enjoying the liberty since, my lord, 2000.
That's the whole problem, sir, in GR case number 591 of 2013 by the SDJM Jashpur. Paragraph, according to the petitioner, relying on the judgment in Daulat Ram versus State of Haryana, 1995 1 SCC 349. It is contended that bail once granted cannot be mechanically cancelled by the trial court without adducing any reasons whatsoever. Paragraph. Having heard learned counsel for the petitioner and having perused the judgment of the Supreme Court, the court is unable to agree with the petitioner that the trial court has, that is the SDGM Jashpur, has committed any error in cancelling the bail granted to the petitioner. Full stop. The order dated 9th October 2013 of the SDJM Jashpur, which is assailed in the present petition, spells out that a report was called for from the investigating officer, bracket IU, who then submitted a report confirming that, open quotation, on 5/10/2013 during morning hour, accused abused the father of the victim, ... and threatened with dire consequence. Full stop, unquote. The report further confirmed that, the impugned order further shows that, in addition, the complainant who was present before the court contended that the accused had terrorized them and abused in obscene words on a public road and humiliated them in public. Paragraph. It was in the above circumstances that the bail granted to the petitioner was cancelled. So this was not a mechanical exercise of cancellation of bail without any reasons whatsoever. Consequently, the court is not satisfied that any cases be made out for interfering with the award dated 9/10/2013 of the trial court. Full stop. The petition is accordingly dismissed. The interim order is vacated. Time to the petitioner to surrender is granted till 1st August 2022. Failing which, the IAC of the concerned police station will immediately take steps to have the petitioner apprehended. Paragraph. It is clarified that this order will not prevent the petitioner from further applying for bail at an appropriate stage.
My lord. And my submission, my lord, one, no FIR register on the allegation of the complainant.
All right, you say counsel the petitioner contended that unless an FIR was registered on the allegation of the complainant, the bail granted to the petitioner could not have been cancelled. The court is unable to agree. Once a report is called for from the IO, confirms that the petitioner threatened the complainant, that was sufficient for the trial court to have cancelled the bail.
Please. The condition on the bail is that he'll not commit such, that is also recorded, so.
Whatever the conditions,
Yes.
sir, we're not interfering with that.
Item 66.
None appears, this was not a solution.
Specialist item 67.
May it please, my lord, I am in BC, my lord, I am also.
Yes.
My lord, the prosecution was launched by the forest authorities for violation of the environment impact notification 2006 for the year 2008-2009. On the ground that there was an enhanced production without obtaining necessary environmental clearance. My lord, under section 15 and cognizance has been taken on section 19 of the Environment Act.
Right.
The petitioner seeks to challenge the same. Now
Yes.
I'm going through the records of the case, my lord. I find that a discharge petition is also pending before the.
So you can pursue that, sir.
And in the meantime, another development your lordship is aware that in the common cause after the Honorable Supreme Court directed that levied compensation in respect of pro rata compensation in respect of the excess production which the petitioner has already paid.
That can be brought to the notice of that court.
Your lordship may kindly grant me the leave
All
to
right.
file it by way of additional affidavit to bring it to the notice of
All
the
right.
court along with the discharge petition.
Mr. Ashok Manthi, learned senior counsel appearing for the petitioner, states that during the pendency of the present petition, a discharge petition has already been filed in the trial court. He seeks leave to withdraw the present petition with liberty to file additional documents and affidavits and an affidavit in the concerned court to bring on record the developments subsequent to the filing of the lodging of the complaint. Full stop. The petition is disposed of with liberty is prayed for. The interim order is vacated. All right, sir.
Specialist item 68. 68.
None appears to assist non-prosecution.
Specialist item 69.
May I please? Sir, Miller's petition challenges the cognizance, order of cognizance at page 28 Miller's annex 4 Miller's. Offense order has been taken, cognizance has been taken 406, 420, 467, 294, 506, 34. Type is Miller's. Miller's fact is like this, Miller. Brother of the petitioner regarding civil dispute, brother of the petitioner lodged a FIR that my elder brother has made a false declaration of my mother to grab the entire property, Miller's.
This you can, all the things can be erased. So there.
Let me. Let's on the similar self-same prayer, he has lodged a complaint case before the district of Balgat, Milord, and one court has directed to take directed the police to take action against him, Milord. In self-same fact of the cases, Milord lodged complaint case before the ADGM Baleswar, and this ADGM Baleswar directed to the police to register FIR under 156(3), Milord, and police has registered a FIR, Milord, and submitted a final form. Thereafter, Milord, they have filed a protest petition, and on basis of protest petition, that cognizance taken, Milord. And in the same time, Milord, civil suit is pending before the district judge Balaghat, Milord. Milord, same set of fact, Milord, this person is cannot be prosecuted twice, Milord.
Yes. All that you can seek in the discharge, sir, there. Permitting the petitioner to raise all the pleas raised in the present petition.
Yes.
At the appropriate stage in the trial court, the petition is disposed of. The interim order is vacated. Yes.
Specialist item 70.
My lord, item 70, I have challenging the, my lord, questioning of the proceeding on the FIR, my lord, I have filed. In the meantime, I think must charge sheet submitted, I think. on the ground of compromise I have filed. So
So there's no affidavit here, sir. You can always have the statements recorded in the trial court.
my
Once the petitioner claims that the petition and the complainant have compromised the disputes, statements to that effect can well be made before the trial court. Consequently, permitting the petitioner to raise all pleas available to the petitioner in accordance with law before the trial court at the appropriate stage. The petition is disposed of, the interim order is vacated.
Specialist fast or matter item number 24.
May arise out a complaint case, my lord. Lordship, my lord, have a glance to the complaint petition, my lord. Running page 10, my lord, paragraph C. What is the allegation, lordship? That at the time of filing nomination for the post of PS member of Purunabasan Gram Panchayat, the accused enclosed an affidavit as required by the witness number 4.
Sir, all these pleas you can take at the appropriate stage.
Lordship,
We can't examine it here, sir, in the absence of any complainant.
only allegation, lordship. Allegation, my lord, I have not passed the examination. Only that allegation. And my Lord and Magistrate take cognizance under section 177 and 200. That is a false evidence, my lord. I have annexed 4 who passed the examination, my lord.
So you can point that out to the court there, sir. You can always point it out. This has to be examined properly. Probably those persons issuing the certificates will have to be summoned.
My lord,
Permitting the petitioner to raise all the pleas raised here at the appropriate stage before the trial court. The petition is disposed of, the interim order is vacated.
Lordship, the cognizance order, lordship.
You can show it all to the, yes.
Fast or matter item 53.
Here is a case where the opposite parties have appeared, my lord. They're not here before your lordship now.
Sorry, 53.
My lord. My lord, as I showed your lordship, my lord, in the FIR is only on the ground that all these people are complete strangers and I had no idea who they are.
Correct.
Now, my lord, here, but
You
however,
said there was a suit and
there is a suit
and 144 proceedings. before that.
144, my lord, where the police has said, now, my lord, I have also taken just my lord. My lord, here is also a copy of a suit which they themselves have filed against the accused people in 2011, asking for permanent injunction.
All right.
So it's a clear case, my lord, where my humble submission comes under category 5 and 7 of Bhajan Lal, my lord.
All right.
And we have taken this ground.
All right. The petitions allowed, the proceedings are quashed. The detailed order will be passed.
Grateful,
All right.
deeply grateful.
They'll come here or?
Supplementary list fresh addition item number 1.
May I please, Your Lordship?
Yes.
BC, madam. Here in this review application, I have a review of the order dated 27th April 2015. That is at page 15, madam. It starts from page 14. Page 15 is the order, madam. It has to page to 15, madam.
1 minute. Yes.
But here this writ application was filed challenging the order of the revisional authority, rejecting by upholding the rejection of renewal of my mining lease.
Right.
In fact, the original authority, the revisional authority, as well as this noble court has upheld this rejection of renewal of my mining lease on the ground that the petitioner has failed to furnish certain statutory documents and has failed to carry out the mining operation during the original period also, my lord. That's the premise on which my renewal has been rejected, and in the order dated 27th April has so, my lord, on this ground has upheld this order of the revisional authority, my lord. What I submit, my lord, one, I would draw kind attention of your lordship to page 42, my lord.
No, Lord and Council, please come to page number 18. That is annexure 2.
That's the order of the revisional authority.
Right. And read the first 2 lines. This revision application dated so and so has been filed
by the revisionist.
By the revisionist challenging the state government of Orissa's order dated so and so. That means your renewal application was rejected on 1/8/2006, right? You filed a revision application on 14/1/2012, right? And that application was rejected on 35/2014. That is in the top of the order.
Yes, my lord.
Then the writ petition was dismissed. So the what has happened in the meantime? Much water must have been flown under the breeze, and now somebody might have been also engaged for that particular mining.
As regards the rejection in 2006 and my challenge in 2012, I have given the explanation before the revisional authority that the order rejecting my application was furnished to me in 2012.
No, what is the status?
No, but did you continue? After your renewal was refused, you simply continued in the mine.
No, my lord, I could not. In fact, during the period also, I could not mine the lease, my lord.
Right.
What I, my lord, in the ground of my this review application is that this honorable court as well as the revisional authority has not taken into consideration another order of the revisional authority between the self-same parties, where the revisional authority has held that it is but for the laches of the state government that this petitioner could not mine. That order has attained finality.
No, Mr. Paddy, you'll have to still answer the question put to you. See, effectively, then from 2006.
Right, sir.
You have not, it's about 16 years now.
I have not.
You don't have a lease for 16 years.
That's a fact.
In these 16 years, obviously somebody else would have been allotted the mine.
No, that's an instance. It is still not allotted to any other miner.
Is that right, Mr. Katkia?
Yes, please. Order sought to be reviewed has been passed on 27th April 2015. In the meantime, 7 years has passed.
In fact, that instance,
27th April 2015. The order sought to be reviewed.
No, that's true. What is your instruction? No, somebody else allotted this lease.
No, plus that instruction I have got.
That's my instruction. My learned senior can take that instruction. In fact, I have been instructed that this lease has not been allotted to any other person as on date, my lord. So, my lord, that instruction, my learned senior.
For 16 years, no lease has been allotted.
Yes, my lord. This particular area has not been allotted to any other.
And if now the lease will be given, there may be some different condition because in the there may be the price.
Yes, that I will apply. They may consider it. In fact, based on the new conditions, if I am successful, or that's, my lord.
How that can be dealt in this review petition?
Because, my
lord,
you
can file a separate writ petition for that.
My submission is first of all, the state government has rejected my renewal on, my lord, on grounds which are baseless, and that has been held by the revisional authority and that order has attained finality. None have challenged that order of the revisional authority. There, the revisional authority has categorically held that it is but for the laches of the state government that this lessee could not operate the mine. That order has attained finality, and this was, my lord, so I have annexed that order to the writ application, my lord, that has not been considered. So that's my ground in this review application. That
Laches appears on your part when you are challenging a 2006 order in 2012. That is the revisional.
I was supplied with the impugned order belatedly. That's why I challenged it later. That also I explained to the revisional authority. That is so. Hence, they have considered my application on merit, my lord. So I have challenged the order after 6 years. So, my lord, may kindly see page 42. That's the order of the revisional authority which has attained finality. Annexure 6, page 42. In fact, there in that revision application, I had challenged the demand of dead rent by the state government for the original period. There, the revisional authority, my lord, if I take your lordship directly to page 48.
No, unless we get a clear-cut picture that whether this lease has been granted to anybody else or not.
Correct. You say the court would like the learned counsel for the state to inform it whether from
6, sir, annexure 2, page 18, sir.
Yes. From 1st August 2006, when the government had passed an order refusing renewal of the lease in favor of the petitioner, the lease in question has been allotted to anyone else. Full stop. An affidavit to this effect we filed before the next date. List on 2nd September.
Yes.
2nd September. Right. Sir, pranam. Pranam, sir, pranam.
Supplementary stress admission item number 1.
May I please, Your Lordship? Lordship, there was a CMAPL which has been filed to restore a writ appeal which was dismissed for non-prosecution.
What's the writ appeal about? You tell us.
Your Lordship, the facts of the case is that there was a piece of land which, after the death of the owner, dwelled upon 3 sons. One of the sons was unmarried and died. However, before his death, he had adopted a son who had also died in the meantime. So the land dwelled upon 2 sons who, by way of a partition deed in the year 1957, registered partition deed, partitioned the land and divided among themselves. After that, Your Lordship, in the year 1965, one of the sons sold the land to the present appellant, Your Lordship. The present appellant then was a corn processing corporation, which was later converted into a company, Jwala Roller Flour Mills Private Limited, Your Lordship. Your Lordship, in the meantime, the Orissa Estate Abolition Act had came in the year 1951, and the land was vested in the government, and these people were deemed tenants, Your Lordship. So a vesting case was initiated by the brothers. In the vesting case, initially it was observed that half of the portion of the land is in possession of the present appellant. However, by a suo motu initiation by the government, the land was settled in favor of the brothers. The present appellant thereafter moved in appeal to the Commissioner Court. Commissioner Court set aside the order in the vesting case and stated that half of the land has been purchased by the appellant, and that may be settled in favor of the appellant, and the other half may be settled in the favor of the brother. Thereafter, they came in the writ. The writ court, however, Your Lordship, made 2 observations. The writ court.
Where is the order of the writ court?
Writ court order is, Lordship.
It must be in the writ appeal.
It is annexed in the writ appeal, Your Lordship. Give me 1 second.
Yes, page 13.
Page 13, Your Lordship. 2 things was observed. One was the partition is invalid because the Orissa Estate Abolition Act was there. However, the partition was done in the year 1957, and the vesting case was initiated only in the year 63. So till 63, the land was there with the brothers, and hence the partition is valid, Your Lordship. Second observation that the single judge has made, that the registered sale deed is invalid.
No, the partition deed has been held to be a void ab initio.
Void ab initio, yes, Your Lordship.
Not valid.
Void ab initio, but in 1963, the vesting case was initiated. The partition was done in the year 1957. And the second observation which the learned single judge has made, that the requirement of section 54 of Transfer of Property Act.
Yeah, this is correct. The title of the contesting party is pursuant to the purchase made by the registered sale deed should be thrashed out in the civil court.
Yes, Your Lordship, but section 54 doesn't talk about delivery of possession. The learned single judge have taken into consideration that since the possession was not delivered, the sale deed is invalid. First thing, Your Lordship, the possession was delivered at the time of registration of the sale deed. Second, Your Lordship, section 54, may kindly see, Your Lordship. I'll read out. Sale how to make. Such transfer in the case of tangible immovable property of the value of 100 rupees and upwards, or in the case of a reversion or other intangible thing, can be made only by a registered instrument. The registered instrument is there, Your Lordship. There is no question of delivery of possession. Delivery of possession comes in the second para, where in case of the tangible immovable properties of value less than 100, such transfer may be made either by the registered instrument or by delivery of possession. In our case, it is not a case where the property value is less than 100. So the question of delivery of possession doesn't come. And Your Lordship, with regard to the partition and the sale thereafter, we can also refer to section 43. If at all the learned single judge has an understanding that at the time of possession, since the land was already vested in the government, these people did not have the power to sell. Section 43 talks about transfer by unauthorized person who subsequently acquires interest in the property. So even if we did not have, for the sake of argument, even if we did
not, but if it is government land, there is a question of subsequent.
No, this is not a government land, Your Lordship. The Orissa Estate Abolition Act, what it did, all the lands, Jamindar lands were taken back to the government, wherein the owners were declared as deemed tenant. And,
that's right.
And after filing an application, a vesting case was initiated and the land was settled in the favor. Ultimately, the land has been settled in the favor of the brothers. The brothers are the owners now. So even if at the time of the partition,
are the contesting parties appearing or not?
They are not appearing.
No, were they appearing when the writ appeal was pending?
Yes, they were there, but it was dismissed for default. But my submission is that a valid sale deed is always can be made by three integral parts, that is proper registration, delivery of possession, and payment of consideration money. Delivery of possession is an integral part of a valid sale. So how can he say that delivery of possession is not required? It is a sale deed is that is the finding of and there are several. And add to it, Your Lordship will find that in the impugned judgment, he has given liberty to approach the civil court. These are all civil disputes, and Honorable Court has said, if you have got any title, then you approach the civil court. That it is open for them.
Your Lordship, with regard to section 54 that the learned single judge has mentioned, I have read out the section already.
If you say that delivery of possession is not required for a valid sale deed, then
I am not saying that. I am just saying it for the sake of argument, Your Lordship.
No. How can you
at the time of the registration of sale deed,
part of a valid
the possession
sale
was delivered to us. I have constructed boundary wall in that area. I am in possession. But even if the question of delivery of possession was raised, I would like to say section 54 does not talk about delivery of possession as a mandate. It only says that it can be made only by a registered instrument. With regard to properties whose value are less than ₹100, either a valid registered instrument or by
No, and how is this appellant number 1 is a private limited company?
Appellant number 1 is, Your Lordship, a private limited company.
How is that? How does it get title or any interest?
That, Your Lordship, I'll satisfy. I do not have the documents of the original OGC case, Your Lordship. The reason why this was dismissed for non-prosecution is that, Your Lordship, the authorized representative who was taking care of the case died during COVID, Your Lordship.
No, that we're not into. We're on the we maintained the instance of a private limited company, and it seems to be a partnership dispute.
I understand.
Partition.
I'll satisfy Your Lordship on that once I get the OGC records, Your Lordship. Once the OGC is tagged with this case, I can have the records. I don't have the records.
You say for the reason stated, the application is allowed.
My lord, the private opposite parties are there, so they should be.
Yeah, and the writ appeal, let the notice go in the writ appeal to them. All right. The writ appeal 187, order dated 13/9/2021 is recalled. And writ appeal number 187 of 2008 is restored to file. In the main writ appeal, you say, since the writ appeal has been restored pursuant to an order dated passed today, in the same APL. You say, notice will now go to all the opposite parties other than the state of Orissa, private opposite parties other than opposite party number 1, respondent number 1, returnable before the roster bench on 26 September.
Obliged.
All right.
The submission item number 2.
May it please your lordship, my lord, it was dismissed due to my non-appearance. I was on my legs, your lordship.
What's the main matter about?
My lord, this was a PIL where the people of a area were protesting the construction of a multi-purpose Kalyan Mandap inside the premises of a high school. Now, there are 5 types of schools functioning in a premises, and within that premises, they were to construct this multi-purpose Kalyan Mandap for all feasts and all get together. This will completely hamper the atmosphere of the school. My lord, at flag X, page 5, the RI has given a report that yes, a multi-purpose Kalyan Mandap is being constructed within the premises of the school. At flag X, annexure 5, page 5 also.
That is school and mass education department is to be noticed.
Had they filed an affidavit? They've been asked to file an affidavit.
In the original writ petition.
Rather, we have filed an affidavit.
It says counter affidavit of OP number 5.
OP number 5 is, my lord, BDO Kontapada. Yes, that must have been filed by us. But the school authority, they are included as opposite parties. And I don't know whether they have filed their counter in the writ petition.
Have you got copies of this counter of OP number 5?
Yes, your lordship.
No, they were to file an affidavit, I thought, pursuant to an order of this court. See, on 8th December 2021, we had passed an order. Affidavit of state to be filed before 1st February 2022. They did not file this affidavit?
OP5 has filed an affidavit.
No, not after December 2021. It's prior to, I think. Just see that OP5, that affidavit is not scanned. I think. What is the date of that affidavit filed by OP number 5?
27 June 2022. 22, my lord. Yes.
Somehow we don't seem to have a copy of that.
Maybe they have not filed with the registry.
All right. So for the reason stated therein, the application is allowed. The order dated 7th March 2022 is recalled. And writ petition civil 13990/2016 is restored to file. Then main writ petition is said today it's been restored by this order. The affidavit dated 27 June.
27th January 2022.
Is there? Page?
58.
It's 27 January.
27th of January.
You want to file a reply to that?
I'll file a rejoinder.
The petitioner is permitted to file reply to the affidavit dated 27 January 2022 of the opposite party number 5. List this writ petition before the roster bench. On 7 September 2022.
For admission item number 3. My lords, I appear for OP5, my lords, the licensee.
This has become impugned.
Lords, it's squarely covered by the order of
the impugned order has already been implemented since
my
long.
lord.
They're opposing because they are having some publicity interest litigation, my lords. But the rule 27 itself is not applicable because it's an ops of, my lords. So there is no harm being caused, and they're anticipating a breach that will happen. Some fundamental right will be impacted and all.
No, but who's applied for modification of the order?
My lords, I applied for a modification because, my lords, they gave an undertaking which was under a false premise that the shop was opening, shop was closed, my lords, but the shop was open. So therefore, the status quo which was passed on the basis of the learned council's premise undertaking was itself factually incorrect, my lords.
Who's appearing for the Mr. Mishra is there?
Yes.
Mr. Kali Prasanna Mishra.
That shop is already shifted and he is running his shop at this perhaps. So
yes,
the shop is shifted.
Shop is shifted.
Since long.
Since long.
This dispute no more survives.
And rule 27 itself is not attracted, my lords, because
That
it's
is a merit on merit. My learned friend is submitting, but as on date there is no dispute. The shifting order has already been implemented. He is now running the shop at the new place.
What is the new place?
My lords, that is there in Mauja Ghatikia. So that
At Ghatikia.
new place is mentioned in para 1 of the reply filed by the OP5, my lords.
No, sir, see the order, our order dated, the last order, August order, para number 5. Based on the statement of the council for the.
Correct.
The status quo order was passed. Now he is submitting that on the date of passing of that status quo order, the shop has already shifted and that statement made by the petitioner was a false one.
All right. Actually, in this application, we issued notice, but nobody's filed a reply.
My lords, reply is filed, my lords.
Reply is filed.
OP5 has filed a reply.
Saying what?
My lords, my broad contention is that, my lords, on merits, because it's an on-shop, my lords, the specific contention which is raised by the petitioner that it is impacting their fundamental rights and all that will not get attracted because it's an on-shop. And it is already covered by another division bench order of this honorable court also, where it specifically mandates that the on-shop can be permitted in if it complies with the statutory mandate under Rule 26 and Rule 27, my lords. And more or less, my lord, they are anticipating that there will be a fundamental right violation, and no such instance of violation has been reported by the local police authorities also. Therefore, my lords, when there is no violation of fundamental rights, how can they maintain a PIL?
You have served the copy of your reply as well as the IA on the counsel for the petitioner.
Yes, my lords. The copy has been served and receipt to that effect has been also filed with the court also.
So we'll modify that interim order, sir, and here the very.
All right. You say IA number 11725.
No, my lords. 13540. 13540 of 2021.
No, your IA.
13540. Right. IA number 135. In this IA, no reply has been filed.
My lords, because that was not required also, my lords.
No. I think you issued notice in this IA.
Yes.
Notice was
the petitioner has not filed. Actually,
13540 2021. This is an application filed by opposite party number 5 seeking modification of the status quo order passed with this court on 26th August 2021, recording a statement by senior counsel for the petitioner that despite the IMFL on-shop of the petitioner having been permitted to shift to plot K7 Kalinga Nagar.
Well, it's IMFL off-shop, my lords.
Off-shop.
Off-shop.
To plot K7 Kalinga Nagar. Open quotation, the said IMFL off-shop has not been allowed to operate till date, unquote. It is contended in the present application that the above statement is incorrect and that the petitioner had been operating the said shop at K7 Kalinga Nagar and continues to operate it till date. Paragraph. Notice was issued in this application on 21st September 2021 permitting. No, you say in this application, when this application was listed on 21/9/2021, the non-applicants, that is the petitioners, were permitted to file a reply. Till date, no reply has been filed to this application. Paragraph, the assertion of the applicant opposite party number 5 that he continues to operate at K7 Kalinganagar has been confirmed to be correct by counsel for the state.
Yes.
Full stop. In that view of the matter, the court modifies the order dated 26th August 2021 by vacating the status quo order passed on that date. Full stop. The application is disposed of. In the main writ petition, we say now the writ petition will be listed before the roster bench on 21st September.
Grateful, my lord.
One. May I please, my lords?
Yes, please.
My lord, kindly have a glance to minors order dated 24/12/2021. The appellant number 1 was suffering from different ailments. Taking into the background of the case and looking into the report of the Superintendent Jail Barampur, the minor has granted interim bail for a period of 12 weeks. The petition, I have moved for bail of appellant number 1 only. And after expiry of the interim period, in IR number 796 of 2022, I have filed the surrender certificate. Page.
What is his age now?
Age 86, my lord.
86.
My lord, I pray bail, that's why.
And how long has he been in custody?
My lord, after conviction, he is in custody, and during period trial, he was on bail.
No.
From the date of judgment, he is in custody.
That's 2020.
10th January 2022.
So more than 2.5 years.
More than 2.5.
But he's 86 years.
Any stage, 86 years.
All right. The applicant, this is an application for regular bail. The applicant was convicted by the Additional Sessions Judge Aska Ganjam in ST case number 132 of 2013 for the offence punishable under sections 302, 201 read with 34 IPC by a judgment dated 10th January 2020 and sentenced to undergo RI for life, pay a fine of 10,000 and in default to undergo RI for 2 years for the offence under section 302 IPC and to undergo RI for 5 years, pay a fine of 5,000 and default to undergo RI for 1 year for the offence under 201 IPC paragraph. Applicant number 1 is stated to be 86 years old at present and suffering from various ailments. It may be noted here that earlier this court granted him interim bail by an order dated 24th December 2021, pursuant to which he has he stated to have been treated at the cardiology department at the MKCG Medical College and Hospital, Berampur. The applicant surrendered promptly in terms of the said order. It is stated that he continues to suffer from different ailments. Stop. The fact of his suffering from ailments and his age is not disputed by counsel for the state. Paragraph. In the circumstances, the court directs that the petitioner, the applicant, appellant number 1, be enlarged on bail during the pendency of the criminal appeal, subject to the satisfaction and the terms to be incorporated by the trial court. The application is disposed of.